Thank you. Good morning, all. This hearing is in the matter of CFI 002-2024 and is being held by way of video conferencing before Chief Justice Zaki Azmi, Justice Robert French, and His Excellency Justice Shamlan al-Sawalehi, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The applicant is represented by Homan Fenwick William Middle East. Lead counsel is David Walsh. The respondent is represented by El Tamimi and Company. Lead counsel is Charles Doherty KC. Thank you.
David Walsh. Yes, Mr. Walsh, David Walsh. Walsh and Mr. Charles Doherty. That's how you pronounce your name? Doherty?
Doherty, Your Honour.
Doherty. Okay, Charles Doherty. That's Irish.
It is Irish in origin.
Okay, thank you very much, Mr. Walsh. You want to start off?
Thank you, Your Honour. So I represent the appellant in these proceedings, who was the first defendant in the underlying proceedings. That's Emirates Insurance Company, PSC. It's an insurance company established by Law Number 6 of 1982, and it has branches across the UAE. I'll refer to my client, the appellant, as EIC. My learned friend, Mr. Doherty, or learned friends, Mr. Doherty KC and Mr. Killen, represent various companies in the Lals group. They were the respondents. They're the respondents to the appeal, the claimants in the underlying proceedings. Lals is a retail group which operates and owns shops and restaurants and the like across the GCC. And for ease of reference, I shall refer to them compendiously as Lals. Kennedy's, the law firm, are, I believe, here on a watching brief for the brokers. That's the second defendant, and the brokers are playing no active role in this appeal, and I don't believe are represented by counsel either today. Before I start my submissions, can I please check that the court has the electronic bundle that was filed?
Yes.
That should contain all the documents that we need for today, orders, authority, skeletons, and the like. In terms of timings, the court was sent a proposed timetable last week, which is agreed between the parties, but obviously subject to the court's approval. That plan was that I would speak in the first instance for about 2 hours, perhaps slightly less. So that would take us up to about 1 p.m. UAE time. We then proposed breaking for half an hour with my learned friend, Mr. Doherty KC, then making his submissions for about 2.25 hours. So that would take us up to about 1:30, from 1:30 UAE time to 3:45 UAE time. And that would leave me whatever remains of my time left to wrap up by 4 p.m. UAE time. I don't know if that is acceptable to the court.
Yeah, that's what we agree. Okay, that's good.
Well, on that basis, I shall crack on. The court would have seen that this is an appeal from a judgment of the court of first instance, Mr. Justice.
Before we start, Judge Peter Gross went at length on describing how insurance policy is to be interpreted. Do you generally agree with what he has put in his judgment?
I think if you're referring to the sort of general principles of contractual construction, I think we are in broad agreement on that. I think where the difference between us lies is what one does in cases where there is at least apparent inconsistency or discrepancy between clauses covering the same subject matter.
So we are interpreting. You're not going into the policy, the terms of the policy itself. But generally speaking, you accept what Justice Peter Gross has stated in his judgment relating how an insurance policy should be interpreted. He went at great length to explain it.
Yes,
that's the first question. The second question is what's the other second question that was about to ask you? What? Okay, you then interpretation of how much should a court of appeal intervene in interpreting an agreement, interpretation of agreement by a court of first instance. How much should it disturb the findings of interpretations by the court of first instance? And English courts, I think the trend is not to interfere too much unless the judge has obviously gone astray in his interpretation. Otherwise, that is the second point that I would like to hear from you, basically. I didn't know what the other judges had to say, but those are the things that crossed my mind immediately.
Of course.
Thank you.
Well, the issue here is one purely of contractual construction. So the question is how the policy falls to be construed as against the principles of construction that are broadly common ground. As I say, there is this slight, I think, divergence of emphasis between parties where you have clauses covering the same subject matter. I think my learned friend, he would say, well, if you have clauses covering the same subject matter, each operates in its own right, and you can be more relaxed about that. Whereas I think we would stress those authorities where, or those cases in the common law world, where the courts have tried to interpret the contract in a more harmonious and congruent way. So I think there is a slight difference of emphasis in those authorities, in the emphasis in the argument there between us. But on the whole, I think we are agreed broadly as to the principles of contractual construction that apply and that were outlined by Justice Sir Peter Gross at first instance.
That raises the question, if you're not asserting an error of principle on the part of the judge at first instance, what then is the standard of appellate review? There is a string of Canadian cases which enunciate a notion of substantial deference, unless it is a standard form contract where the decision will be of precedential value. I didn't see any reference to the standard of appellate review in the submissions, and I just wonder what your position is on that. I do think it may not make a difference in the outcome, because, but I do think we need to address it.
Yes, Your Honour. I think. So I think there's potentially. Can I just first address the second point that was put to me, and then I'll try and make sure I answer your question as well, Your Honour. Let me try and take them in turn. I think the two are related. The second question that was put to me was, well, to what extent should an appellate court review, because it's effectively a question of contractual construction, and should that be something that's interfered with? Obviously, it's different to a question which is highly fact sensitive. We're not in that territory. So the usual deference one might show to a judge at first instance for that reason, because he's a fact finder, wouldn't apply here. This is simply a question of law, and the question for you is whether the judge went wrong as a matter of applying the law to these particular contractual provisions. I think that maybe answers your question as well, which was
I don't think it does, with respect,
okay,
because
apologies.
The Canadian cases certainly don't treat it as a pure question of law. It seems to be regarded as a question of mixed fact and law, whatever that means. It's rather an elusive concept. But certainly the notion of substantial deference seems to be there. And I think there's some reference. I haven't had time to research it fully, but there seems to be some reference to a similar approach in the English authorities. So all of the English authorities, as far as I can see on a quick scan that you have cited, are straight into the terms of the contract, rather than looking to the standard of appellate review. I looked in particular at the FCA decision in the Supreme Court, and they went straight into that. Anyway, you have your position, and I'll reserve mine.
Of course, and in the end, it may not make a difference in terms of the answer. In my submission, what the appellate court here is doing is looking at whether the judge. Of course, it's a mixed question of fact and law, in the sense that one is not just dealing with an abstract legal question, one's applying it to a particular policy. But I suppose my emphasis on its legal analysis is that we're not here dealing with an assessment of witness credibility or really any documents other than the policy itself. That's all we're concerned with. So
you may be dealing with a case in which you have two constructions reasonably open.
Well,
the judge himself seems to have acknowledged that, really, in
exactly
his judgment.
Exactly, Your Honour. And I think in the end, that's probably where one gets to, because although I will submit to you that when one looks at the linguistic differences, my construction is to be preferred, I am not here saying to you that Mr. Doherty's position on construction is unarguable and cannot possibly be made passing the red face test, as it were. I'm not suggesting that to you. And I think in the end, it comes down to, did the judge give enough credence to those authorities dealing with congruence and coherence when he engaged in his legal analysis? And we say he did not. Obviously, he was shown the authorities, but we say that he erred in that. And I think, and hopefully I'll try and unpack that for you in due course. But I'll take the argument in stages. I will deal with the linguistic points, because obviously if the construction I'm putting to you just doesn't fly at all on the words, I recognise I don't get past first base. So I have to persuade you of that. I recognise that. And then you may well find yourself in a world where you are dealing with two possible constructions, and then which is the more commercial. And we'll come to that as well. So I can tell that you're all up to speed, but I with the issues in this case. But I do want to, if I may, just take you back to the firstly to where I'm intending to go with my submissions today. So I'm hoping to cover the following terrain. First of all, I'm going to go and look at the policy and the terms so you can see them in their proper context. Obviously, we've both set out provisions in our skeletons, but it's important to see the contractual documents and to understand how it all fits together. Then I'm going to go back and just remind you of the preliminary issue that we're considering on the appeal and the judge's answer on that. And then I'm going to develop my arguments further as to why the judge erred at first instance and why he was wrong, and therefore why the appeal ought to be allowed. So starting with the policy terms, there are three policies, but they are materially identical for present purposes. So I only need to show you one of them. And that's, I'll show you the one beginning at page 541 of the electronic bundle, if I may.
541.
Yes, Your Honour.
Okay.
Do you agree with His Honour's treatment of the relationship between the schedule and the substantive provisions?
Yes, Your Honour.
Yeah.
I mean, so the starting point is this is in very familiar form. You have the schedule, which is going to be the document that's effectively negotiated between the insurer and the broker, which identifies the various things, but also importantly the sort of headline terms that are then going to be incorporated from various boilerplate terms that either the broker has available to them or the insurer has available to them. But on page 541, we see it's a property, all risks and business interruption insurance. And the names of the insureds are then identified, broad categories of insureds. And then the period of the insurance, about halfway down the page, it begins in July 2019 and extends to the end of June 2020. And so it was entered into pre-pandemic, but covers the first few months of the pandemic in this part of the world. So then we look down immediately below that, one can see that there's just a bit further down, there's a scope of cover provision in the schedule. Property insured or part thereof being accidentally and or physically lost, destroyed or damaged due to any cause other than those specifically excluded, plus business interruptions and additional benefits and extensions as indicated in the slip. And I think we're all agreed that the slip is the schedule, effectively. That's what it's referring to. So it's a classic property damage with business interruption cover, and then some bolt-ons to the business interruption cover, extensions to that, which are then identified. And then if one looks below, just at the bottom of page 541, we see the extension clauses, and there are references there to the sub-limits applying. And if you see there are 3 policy numbers that are referred to. Those are the three policies that I've just been talking about. So effectively, although there are 3 policy documents, the sublimits apply across the policies that are identified. And then we can skip down a bit because the section 1 is obviously property damage. And if one goes down to page 545, we see the specific business interruption clauses. And if we go down, the first one to touch on is what's called customs extension. That was dealt with in the Court of First Instance's judgment, but it's not something that needs to concern us unduly today, but I highlight it because it is dealt with in the judgment there. More importantly, immediately below customs extension is what we've called the closure clause, or at least it's a bullet point identifying the closure clause that we'll then come and have a look at in a moment. Closure due to vermin, murder, suicide, infectious or contagious disease, manslaughter, food and drink poisoning, 25 million dirham.
Now that's an aggregate, isn't it? It's not per incident, as distinct from what appears in relation to the loss of attraction clause.
Yes. So we'll see that on the next page, just at the top of page 546, loss of attraction, limit 25 million dirham, any one occurrence and in the aggregate. Always slightly curious turn of phrase, but there we are. It is what it is. One sees it in various other sorts of policies as well. And in the aggregate, 48 hours excess, radius 1 kilometre, BI excess to apply. That's probably all I need to show you in the schedule. If one goes on to page 549, the court will see the beginning of a document called Combined Material Damage and Business Interruption Policy. And so these are the clauses that are referred to in the schedule, but are then fleshed out, and it gives the detail of the clauses. And it starts with various provisions about how about the nature of the cover. But if we go on to page 579, we see the business interruption clauses that we've just seen referred to in that bullet point list, but actually we now see the detail of them. So at the bottom of page 579 is the customer extension clause. Again, that was referred to in the judgment, but we don't need to deal with its particular terms today. But over the page, we see the closure clause. So top of page 580. So the indemnity under this clause is extended to include interruption or interference with the insured's business in consequence of closure or evacuation of all or part of premises by order of local and national health authorities, competent government, public or statutory authorities, as a result of manslaughter, murder, suicide, vermin or other pests, food or drink poisoning at the location, or within a radius of 2 kilometres of the insured's business, which shall prevent or hinder the use of the insured's business premises or access thereto, or results in a cessation or diminution of trade due to temporary falling away of potential customers. This extension shall trigger even though there is no insured peril acting on the property cover.
And that was extended to infectious, or at least read as including infectious or contagious diseases, and you're not challenging that, obviously.
Correct, Your Honour. So those words appeared in the title, and they appeared in the schedule, but they didn't appear in the body of the clause, and the Court of First Instance concluded they should be read in one way or another, and we don't challenge that.
Not to be read by pedantic lawyers, I think is the expression.
There may be something in that, Your Honour. Now, pausing here on the closure clause, we say that in order to bring, for the policyholders to bring themselves within this cover, it needs to demonstrate 6 things. Firstly, you need an interruption or interference with the business. Secondly, that needs to be in consequence of a closure or evacuation of all or part of the premises. Third, that this was caused by an order from one of a number of specific types of bodies. So that's the local and national health authorities, competent government, etc. Fourth, the order must be because of one of the specific reasons in that closed list: murder, manslaughter, etc. And as Yorna has already indicated, we must add infectious disease to that closed list, but it's only for those reasons, nothing else. Fifthly, the relevant manslaughter, murder, or vermin must have occurred within a 2-kilometre radius of the business. And sixthly, and lastly, there must be a prevention or hindrance in the use of the insured's business or access thereto, or at least some impact upon trade. So the court will be familiar with the fact that this is what the authorities call a composite peril. Each and every one of those 6 limbs of the clause I've just identified need to be present in order for there to be cover for closure. So that's the closure clause. And then if we move on 2 pages to page 582, we see the loss of attraction clause, which is the clause that we are principally concerned with today. So the insurance by this policy extends to include consequential loss as insured by this policy, but resulting from interruption or interference with the business in consequence of, and then we have A to E. A is property damage in the vicinity of the insured locations, etc. B, unlawful occupation by any person taking part in a labour dispute. C, presence or suspected presence of harmful devices in the vicinity. D, closure or sealing off of the insured locations or any right of way by the police or other statutory authority. It's obviously the important limb for present purposes. And E, extremes of climate, and then which, and then we have Roman 1, prevents or hinders the use of the insured location, or 2, causes a reduction in the number of people using the insured location. So it will immediately be apparent that limb D, before we get to limb D, it will immediately be apparent that this loss of attraction clause is broader than the sorts of loss of attraction clauses one often sees in these sorts of policies. Usually, not invariably, but usually, they are concerned with some form of property damage in the vicinity of a particular insured location, which has an impact on the draw or appeal of that location. That's really what is meant when they're talking about loss of attraction. It's the attraction of the insured location being impacted by, I don't know, a bomb or some damage at an airport which prevents people getting there, or if it's part of a complex, some other bit of the property being complex being damaged such that you can't get in, and that sort of thing. And obviously that's really what limb A is talking about here. And we're dealing with B, which is limb D, which is obviously has a different focus. But it's important to appreciate that limb D is just one part of a clause dealing with a wide-ranging array of circumstances in which the business can be interrupted or interfered with. Put differently, closure of the insured location is not the sole focus of this clause. It is but one. Now,
so this is in your general proposition that this is the general clause which can't set aside the limitations in the more specific provision.
Yes, Your Honour. Now, obviously, in order to bring oneself within the loss of attraction clause, we see this in the preamble, you do need an interruption or interference with the business. And then in order for the cover under D to be engaged, you just need a closure or sealing off by the police or other statutory authority of the insured location or any right of way. That's it. It is completely unconcerned with the reason for the closure or sealing off. And we say that this highlights what is a or the central issue on this appeal. You have a closure clause, which, as we have seen, is very carefully calibrated to provide 25 million dirham of cover for closures only in very specific circumstances, i.e. that closed list of very particular reasons why the order is made. And then you have another clause, which we have on the screen in front of us now, where you have 25 million dirham of cover under Lim D for closures for any reason whatsoever. And in those circumstances, we say, well, we ask, is it really right that those clauses, properly construed, are actually aimed at the same target? i.e. the same sorts of closures. And we say, as a matter of common sense, that cannot have been the party's intention. And to reach the opposite conclusion, as the judge at first instance did, with respect, results in what has been called in another case, profound incongruence and incoherence in the operation of the policy. And we'll come to that case shortly. We say that a careful textual analysis shows that the clauses are actually dealing with two things. But in the end, if one is left with two constructions which are both plausible, we invite the court to side with the construction which actually brings congruence and coherence to the policy as a whole. So that's what I wanted to show you so far as the policy itself is concerned. For good order, I should briefly remind you of the preliminary issues, so you have them for your reference. They were set out in the case management order of His Excellency Justice Nasir Al-Nasser, and you can see those at page 90 of the bundle. Preliminary issue 1.1, or issues under 1.1, concern the customer extension clause, which I've shown you, but we don't need to particularly worry about in these, in the context of today's appeal. What is of more interest is obviously preliminary issues 1.2, 1.3. The actual details of the debate between us on preliminary issue 1.2 are probably not important for today's purposes, but obviously the closure clause is very relevant for today's purposes. And then 1.3, the proper construction of the loss of contraction clause, in particular, whether it provides cover limited only to a specific local instance, where the police or statutory authority seal or close up a particular premises, or whether it responds to a national or regional government response to a global pandemic. And then if we look on to page 93, we see the first part of the judgment of Sir Peter Gross, and in particular at the bottom of on page 94, we see his answer on the D, or paragraph 1D, which relates to the loss of attraction clause. And the judge's conclusion is the loss of attraction clause is not limited to a specific local instance where the police or a statutory authority seal or close up a particular premises. It is capable of responding to a national or regional governmental response to a global pandemic.
Would you accept that read in isolation? It would bear the construction that His Honour put on it. Let's suppose the closure clause was not there.
If the closure clause was not there,
yeah,
I would still submit to you that the proper construction is the one that I am pushing for. But again, I would accept that it's Mr. Doherty's construction is an arguable one, but mine was to be preferred, I think I would probably say. But the presence of the closure, I'm trying to be realistic. The presence of the closure clause is the clincher here.
That's really at the centre of your argument.
I need to, as I say, I need to persuade you that my construction is at least an arguable one. As I say, I would go further, but you know, I'm not going to sit here and pretend that we'd all be here today if the closure clause wasn't there as well.
Yeah. Okay.
So that was the judge's conclusion on the proper construction of the LOA clause, and I think that probably covers the ground that I wanted to cover by way of background. And I'm now going to try and elaborate why EIC invites the court to allow the appeal. And it's essentially for three reasons. The first is that the CFI failed to appreciate the significance of the linguistic differences between the closure clause and limb D of the LOA clause. Had it done so, it would in fact have appreciated that they were aimed at different targets. The second, and probably more important, submission is that the CFI failed to interpret the closure clause and limb D of the LOA clause in a commercially sensible way, as we've already said, leading to profound incongruence and incoherence in the operation of the policy. And third, we say the CFI should have followed similar approaches taken by judges in other common law jurisdictions in similar cases, not as a matter of binding authority, of course, but because they fortify the conclusion for which EIC contends on this appeal. So I'll take you through those in turn, if I may. I will be tracking some of the submissions we've made in writing, and where I do so, I will draw your attention to those and the relevant page that we find them at in the bundle. In particular, where I'm trying to highlight the different clauses in the various cases, it's probably more convenient to do it by reference to our skeleton, which sets them out side by side in hopefully a convenient manner. I'll also try and pick up along the way some of the points that Lals have made in writing in response to our case, but obviously as well I'll deal with whatever points my learned friend raises orally by way of reply as well. So I'm saving some time for that.
There's only so much help that one can get from decisions in other cases involving differently worded clauses, I suppose.
We would agree with that.
Factual matrices.
We would agree with that, Your Honour. And in a sense, that's why we cavil somewhat at the suggestion that cases like Marrickville are distinguishable on particular phrases or words that aren't in our clause. It's not really about that. It's about the actual underlying approach and whether that's right or not. And we say that cases like Marrickville and in fact other cases like the China Taiping Award, which is, you can see what Lord Bance is doing and saying, well, actually, I can't quite apply that Marrickville approach here because the clauses are actually both very specific. That gives the court a clue as to the right way to approach this.
When you're coming down to the wire, the way you opened was really that the primary judge didn't give enough weight, if you like, to the terminology and purposes of the closure clause. And that's highly specific to this contract, isn't it? I mean, you can talk about people giving more weight or less weight to interacting clauses in other situations, but they don't enunciate thereby principles of law, do they? They just...
Well, the principle of law is where you have one clause that is specific to a subject matter and another clause which is in much more general terms, whether one yields to the other. Now, I accept that in each case one has a judgment call to make as to, well, which side of the line do you fall? And is this actually two very specific clauses, or is it one general, one specific? I accept that.
Or is it somewhere along a spectrum between?
Or is it on somewhere? Of course. But we do say it's highly persuasive to this court to see a case like Marrickville, where the parallels are extremely close, we would suggest. Of course, it's not exactly the same clauses, but the parallels are very, very clear. And we say that that is persuasive to this court in terms of the analysis that it ought to bring to bear in this particular case. So, yes, I don't pretend that I'm showing you a case where, well, these words are the same, the factual matrix is the same. Of course not. It's about the common approach that ought to be taken.
Yep, okay.
So I need to start with language. And the court will have well in mind that under Articles 49 and 50 of the DIFC contract law, the policy is to be interpreted objectively. Under Article 52, the provisions of the policy must be interpreted in light of the contract as a whole. And under Article 53, the policy must be interpreted so as to give effect to all the terms rather than deprive any of effect. And if you need it, those are contained in the bundle at page 744. I don't think we need to turn it up. They'll be very familiar, I suspect, to the court. Now, we've already touched upon the significant discrepancy between the closure clause and the loss of attraction clause, in the sense that the reason for the closure is irrelevant when it comes to the loss of attraction clause. But we also say that there are other important linguistic differences insofar as the two clauses relate to closures as well. And we identify those at paragraph 7 of our supplemental appeal skeleton, which is at page 706 of the bundle. And it may be helpful to make my submissions on this subject by reference to those paragraphs. It's important, before I start, it's important to stress what we're saying here. We identify these four differences in language. And the point here is cumulatively, they point to the construction that we are pressing upon the court, as opposed to the construction that my learned friend is pressing on the court. I'm not saying that necessarily the first point I'm going to make about the reference to orders is a clincher in of its own right. I don't suggest that. But it's about the cumulative effect of these 4 points and where it shows the court clause is really focused. So the first point in paragraph 7.1 is the fact that the closure clause is dealing with closures by orders, and the LOA clause is not. It does not refer to orders at all. In other words, we say the closure clause seems to be dealing with closures by some sort of instrument or order, whereas the LOA clause contemplates the police, for example, coming and physically closing down a premises. The second point, paragraph 7.2, relates to who is doing the closing down or ordering. And as we say here, the LOA clause is really focused on law enforcement. The primary focus is the police, and we say that other statutory authority in this context means a statutory authority of similar character to the police, i.e. some form of law enforcement. So that could be a counter-terrorism officer, it could be transport police, something of that ilk. And we cite in footnote 4 the Marrickville decision and the analysis of the full court about the meaning of the words conflagration or other, and that this limited catastrophe to physical events. It's an application of the Justum Generis principle. We don't need to turn it up now, but the relevant conclusion of the court is at paragraph 352, which you will find at page 2056 of the bundle. So we don't need to turn it up now. Now, Lals cite 2 English decisions on business interruption policies where insurers unsuccessfully argued for a narrower construction of statutory authority. And we say that neither of those assist in this case. The first is the decision in Corbyn and King, where Mrs. Justice Cockrell concluded, in relation to a different clause, that the term statutory authority was wide enough to include the central government. I'm not going to take the court to that now. No doubt my learned friend will develop submissions on that in due course, and I can deal with it in reply if I need to. But when you read paragraph, and I will invite the court to read paragraph 183 of that judgment in due course, you will see that it does not engage with the Justum Generis argument at all. It simply relies on a declaration in the FCA test case, which was made by consent. The second case is Gatwick Investments, in which Mr. Justice Jacobs endorsed Corbyn and King on the basis it was not clearly wrong, and that takes the argument no further, we say. Again, if the court will see that conclusion at paragraph 136 of Mr. Justice Jacobs' judgment. Again, we say you don't really derive anything from that for the purposes of construing the LOA clause in this case. The key point is that in neither case was it being contended that the words other statutory authority appearing as they do after a reference to the police meant another sort of law enforcement body, and that's the argument that's being made here. So it just simply doesn't address the argument that we are concerned with. And we say that the focus in the LOA clause on closures by law enforcement is in contrast to the closure clause, where you have a much broader range of bodies that can issue a qualifying order: local and national health authorities, competent government, public or other statutory authorities. So the focus is different. And again, we say this reinforces the impression that the LOA clause is focused upon the relevant authority physically attending the premises. The police, as we say in writing, do not ordinarily effect closures by press release or email. They tend physically to attend the scene and tell people what to do. The same is not true if one is considering, for example, local and national health authorities, of course. The third point that we make in paragraph 7.3 relates to the radius. Now, we saw the radius in the schedule that we looked at right at the start of my submissions, the 1 kilometre radius. And the court of first instance agreed that the radius meant that the LOA clause carried with it a local connotation. Now, Lals suggests that the radius does not apply to all parts of the LOA clause. But we've seen the reference to the radius in the schedule, and it does not say that it operates on some of the limbs of the LOA clause, but not others. And we say that the local connotation, which is implied by the radius, is in contrast to the order that is contemplated by the closure clause, which could come from anywhere. So that the order to close under the closure clause could come from a central government building, perhaps hundreds of miles away. Now, Lals says, well, the closure clause also has a radius, which is true. It does have a radius. But the court will recall that the radius in the closure clause is about where the infectious disease, murder, vermin, or whatever else must be present, i.e. it's about that particular murder or vermin being within a radius of 2 kilometres from the insured's business. It's not about where the order to close comes from. And that's the important distinction. And the fourth point that we make in paragraph 7.4 concerns the fact that in the LOA clause, the words closure and sealing off lend colour to each other. The court of first instance agreed that the words sealing off have a physical connotation. Lals agrees with that at paragraph 25 of its supplemental appeal skeleton. And we say that sealing off, the word sealing off, colour the meaning of the word closure in the LOA clause, which also has a physical connotation in that clause. It does not, as Lals suggests, introduce a tautology into the clause or denude the word closure of meaning. It is just reflective of the natural way in which one reads words when they are juxtaposed in a particular clause. And we say that there is a contrast here with the closure clause, where the word closure is paired with evacuation, which does not imply any physical act being done to the premises, whereas sealing off is obviously, as the court of first instance found, something physical. It connotes something physical happening at the premises.
The word by has some significance here, doesn't it? I mean, you're protected against the physical outcome, which is closure or sealing off, and then but you say the range of causes or the causative agent for that closure or sealing off must be some kind of physical activity by police or other statutory authority.
Yes, Your Honour. So the key difference here is it's not the word by in the closure clause is paired with the order, or as you might call it, the instrument, the directive, whatever word you want to use. Whereas in the loss of attraction clause, it's paired with the body doing the act. So it's by the police.
The statutory authority is, on an ordinary reading, a body created by statute. Okay, and it's often a legal abstraction. which can't close anything. It makes an order through people who sit on its board or are its executive officer, its designated officials, and then somebody carries it out. The important thing is, isn't it, the order of the or the action of the statutory authority, which must be an exercise of some statutory power as a result, which is the physical. And the insured surely only cares about being closed off. He doesn't care how it gets there.
Well, it ought to care how it gets there, particularly under the closure clause, Your Honour, because of course it depends on whether it has cover or not.
Yeah.
So the reasons
I mean, in terms of understanding a perspective, I know that Marrickville, they said you don't look at it from the perspective of the policy holder, and happy to accept that.
Much more enlightened than the Supreme Court in the United Kingdom, I must say, because this heresy has crept into the to English law on this point. But the point you're on, I think, is this, and this was touched upon in the judgment at first instance. The term statutory authority is obviously a difficult term in this particular jurisdiction or set of jurisdictions where you might not have bodies created by statute in this particular way. So it's not in the United Kingdom. You might have a very, perhaps even Australia, you might have a more set view. Oh well, a statutory authority is a creature of statute, somebody acting pursuant to a statute. That might not necessarily follow automatically in the Middle East, in the GCC. So we say here,
is there a factual matrix before His Honour which would have informed that approach?
I don't believe so, but I will check that and come back to you if I may.
Sorry, forgive. I cannot see the distinction between, I don't know whether you're trying to make a distinction between what's the difference of physical closure, the police coming in and putting up the barrier and close, and an order. The effect is still closure. I think that's what Justice French was trying to drive at. The effect is still closure. What difference does it make how the closure is done?
Well, it makes a difference because we say that that's the distinction that's being made in the policy. So, for example, you could say in the closure clause, well, why do you care whether you hit one of the closed list of reasons for the closure? If it's closed, it's closed. But the whole point is that you have a gateway to get through in a composite policy in order to establish cover. And the same is true in the loss of attraction clause. Yes, of course, closure is the end result, but how that happens and the mechanism by which that happens is actually important as to whether there's cover or not. So that's the point. And the distinction between so for example, you may have under the closure clause, you may have an official in an office sending out an email saying, we're closing you down because of the spread of coronavirus and you cannot open until further notice. You send an email and you say that's fine. People, law-abiding, no doubt, Lals would say, okay, well, we've got to close up and we're not coming in tomorrow. That we say is qualitatively different to one day the police turning up and saying, right, everybody out, we're putting bollards across the street, you're not coming in, we're physically closing the premises. That sort of situation is going to arise in, we say, different circumstances or potentially different circumstances to an order from a public health body or something of that nature, pursuant to the closure clause. So that we say is the difference, and it matters because it's a composite peril, and unless you can hit each element of the composite peril, you don't get cover, and that's why it's important. And we say that the 4 points that we've just been going through all point to the loss of attraction clause really being focused on something physical, a closure or sealing off happening locally, i.e. at the insured premises or within 1 kilometre if you're dealing with a right of way by law enforcement. And that is different from what the closure clause is aimed at, which is diktats from a public health officer or other state authority to close or evacuate the premises for one of the very particular reasons, the outbreak of vermin, for example, and telling people that you shouldn't come into work tomorrow, that sort of thing. So we say that they are different, and the language is different, and that they are therefore they appear to be aimed at different targets. And that we say is an important first step in the argument that we are making. So we say that conclusion is reinforced when we come to EIC's second argument, which concerns effectively commercial common sense. There are lots of different ways one can put it, congruence, coherence, but in the end, the point is, as a matter of commercial common sense, how do we read the intentions of the parties? And we say that the court of first instance construction of the LOA clause, namely that it responds to any public or state closure for any reason whatsoever, drives a coach and horses through the carefully calibrated closure clause. I've already touched upon Articles 52 and 53 of the DIFC contract law, which place great emphasis on the context in which the clauses appear and the importance of interpreting contracts in a harmonious fashion so as not to deprive any provisions of effect. And we say that the Court of First Instance's construction of Lim D of the LOA clause does offend those principles because it effectively obliterates the boundaries of the cover under the closure clause, depriving them of effect. And this offends not only the principles embodied in the DIFC contract law, but similar doctrines embodied in the unidroit principles and also in the common law more generally. And we've set those out at paragraphs 15 and 16 of our supplemental skeleton. I haven't got time to go through all of those now, and a lot of the propositions are going to be very familiar to you, so I'm not going to do so. The short point here is this. If there are apparent inconsistencies in a contractual document, it's the job of the court, so far as it is possible to do so, to seek to rationalise them. That's the art of contractual interpretation. And the reason the court has that role and does that job is because it reflects the assumption that parties intend to express themselves in a coherent and harmonious manner, unless for some reason the contract is plain as a pikestaff that actually they were very keen on expressing themselves in an irrational or inconsistent manner. And so it's all about trying to ascertain the party's intention.
But you don't say that His Honour enunciated any wrong principle. Your real argument is with his application of principle? Or do you say he didn't really enunciate the principle, just went into a linguistic analysis? How do you characterize it?
He recognised that there is a principle there that one ought to seek to harmonise and read the contract in a congruent fashion. Where he went wrong was that he said effectively, well, I'm more persuaded by the language, so the clauses can operate in effectively a freestanding way, even though there are conflicts and inconsistencies. So he was, if I may put it in these terms, too relaxed as a matter of law, too relaxed on letting the contractual clauses just operate in a freestanding manner without seeking to harmonise them and understand really what the parties were getting at by agreeing these two clauses. And so that is where we say he went wrong. It's not that he forgot that there was this principle. We don't say that. He knew that there was the principle. He just didn't apply it correctly.
That reminds me a little bit of, by way of analogy, of the judicial review of administrative decisions, where you say that the decision maker gave too much weight to some factors and not enough to others, but didn't actually fall over the legal boundary of. It's a bit hard to get up on that.
Yes, I'm not seeking to draw an analogy with JR, thankfully, in my submissions.
I know the bar's a bit specialised.
It is, Your Honour. But I think the point here is we're not saying that he didn't, because frankly, I took him to the cases which said this, and I took him to Marrickville. So I know that he knew that the that line of authority existed. I'm not pretending that it was he forgot that when he came to write his judgment. I'm not saying that. What I'm saying is he didn't give it adequate weight. And of course, if we were, and we'll come to this in a moment, if we were in a situation like China Taiping, and we'll come to those clauses, where I was submitting, you've got to interpret it in a coherent and congruent manner, and the judge was to say, well, actually, both clauses are equally specific or equally general, well, then the principle doesn't apply, and I accept that. But we're not in that territory here. We're not in that territory. So where you have one which is more general and one which is more specific, and you've got these two possible arguments, we do say that the correct legal answer is then to allow the general to yield so that the boundaries of the specific are not completely eroded. And that is we say that's a common law principle. We say it reflects the DIFC contract law as well, which is very clear that you should try and give effect to all the provisions of the contract and construe it in a way that gives effect to all the provisions of the contract. And we'll see in a moment how we say that the court's construction doesn't do that, and that is an error. So we've been through the linguistic differences between the two clauses and explained how they are aimed at different targets. But if the court is in any doubt about that, we say that we say we're right on construction, but even if we're not right, even if you're not with us all the way on construction, it's at least an arguable construction. And we say that in those circumstances, the correct approach is still to read down the more general wording of Lim D on the basis that the closure clause is the specific clause dealing with closures, and that ought to have primacy. And that's a well-recognized way of giving a contract a harmonious and businesslike and congruent construction. And I just want to show the court, if I may, a passage from Lewison on the interpretation of contracts, page 785. And lest it be thought that I'm being too parochial, it is actually a passage quoting an Irish case. And it really encapsulates what we're talking about here. So it's at page 785 of the bundle. And it's the quote. So the principle has been described in Ireland as follows. I won't mangle the Latin, but I'll read from there, from the second sentence. In plain English, when you find a particular situation...
Did you say 785?
785, yes, Your Honour.
But my thing says there's no invalid number. It says invalid page number. Never mind. Just proceed.
Well, no. It's important that you can see it on the screen as well. So the appeal bundle should have over 2,500 pages. Page 785.
I've got the other pages. I've got the other pages you cited earlier, but I can't get to 785.
785.
Something's wrong with my iPad maybe.
Sometimes
if 785. Oh, okay. Just go ahead. You go ahead first. Page 785.
So the quote from the Irish case, and it's appealed in a subsequent decision in England, but it says this: in plain English, where you find a particular situation dealt with in special terms, and later in the same document you find general words used which could be said to encompass and deal differently with that particular situation, the general words will not, in the absence of an indication of a definite intention to do so, be held to undermine or abrogate the effect of the special words which were used to deal with the particular situation. This is but a common sense way of giving effect to the true or primary intention of the draftsman, for the general words will usually have been used in inadvertence of the fact that the particular situation has been specifically dealt with. And that is the common sense reason that underpins these cases. I think my learned friends described the schedule as having a pick and mix approach to the clauses, and we don't disagree with that. But by virtue of the fact you've got a pick and mix set of clauses, What's likely to have happened is the parties have agreed a schedule. They've said to their broker, the policyholder said to their broker, yes, I'd like a closure clause, please. Yes, I'd like a loss of attraction clause. But they have done so without fully appreciating that the loss of attraction clause has a closure limb whose boundaries are rather different to the boundaries in the closure clause. I'm not saying that that's exactly what happened here, but if one is thinking about what might have happened, it's not, we say, an unlikely scenario. And this quote encapsulates why we have this line of cases about the general and specific provisions, that the general words, so in this case lim D, have usually been used in inadvertence of the fact that particular situation, i.e. closures, have already been covered and specifically dealt with, we say, in the closure clause. And the fact that it is a pick and mix schedule and not a carefully drafted unitary contract means that there may well be discrepancies and inconsistencies in the drafting. And that no doubt explains why the policy in this case has its infelicities. But that's precisely why this principle that a contract should be construed as a coherent whole is important. It is not a reason, we say, for abandoning that principle. And that is not to say that one ignores lim D of the loss of attraction clause. We don't say that. What we say is it provides a justification for reading it down so that it does not obliterate the boundaries of the cover under the much more specific closure clause. Now, Lals identify a number of English cases where the courts have concluded that cover overlaps under two particular provisions in an insurance policy, or two or three particular provisions in an insurance policy. Stonegate, various eateries, Greg's. No doubt my learned friend will take you to those. But we say this misses the point. The problem with the construction that is advanced by Lals is not that it results in some overlapping cover. It is that the cover under the closure clause is subsumed entirely within the cover provided by lim D of the LOA clause. And that is what we were trying to illustrate if one goes to page 720 of the bundle with my first foray in a skeleton argument into Venn diagrams to try and explain what we're talking about, what the objection is here. And so we say that we've got the Venn diagram under paragraph 39. And
I say it occurred to me when I read this that we could give a very short judgment in terms of a simple Venn diagram, choosing one or other of which will designate the outcome.
Well, yeah, if they've been hard to grapple with, if they've been of some assistance, then at least I've achieved something, Your Honour. But the thing with Venn diagrams like this, normally one sees this in the context of exclusions. The Venn diagram underneath paragraph 39. So you'd have the bigger circle being the cover, and the smaller circle in it being a carve out, an exclusion. And of course, that's utterly orthodox, and nobody worries about that. What's unusual here is that you've got two coverage clauses in one small circle within the other, and that is what we are objecting to. We're objecting to the closure clause cover being totally subsumed within the LOA clause, and that is problematic because the closure clause says you get cover for closures in these very particular circumstances. And then the great big elephant foot of the LOA clause, lim D, comes and tramples on it and says, forget all of that, you just get cover for closures, full stop. And that is what we're objecting to as a matter of construction and as a matter of construing the policy in a commercially rational and coherent way. And so when my learned friend takes you to these other cases where you have overlap of cover in this particular area, that's just none to the point. That's not what we're complaining about here. What we're complaining about is the complete one cover being completely, the specific cover being completely subsumed within the general clause. So with that in mind, it's time to go to Marrickville, because I've alluded to Marrickville a number of times, and obviously it's a case I like. So I would like to take the court to that, if I may. We're specifically focused upon the tap house policy, and it would be probably helpful, first of all, if I may, to take the court to paragraph 21 of our supplemental skeleton argument, where we set out the two relevant clauses side by side. So we've got and that's at 712 of the bundle. So we've got a closure clause, clause 8, and prevention of access clause, clause 7. And the closure clause, headed murder, suicide, and infectious disease, on the in the left-hand column, we will pay for loss that results from an interruption of your businesses caused by A, any legal authority closing or evacuating all or part of the premises as a result of, and then Roman 1 is infectious diseases within a 20-kilometre radius, with various exclusions. 2, vermin or other animal pests at the premises. 3, hygiene problems, other sanitary arrangements. 4, bomb threat at or to the premises. And then B, poisoning. And C, murder or suicide. So some of the perils that we see, or some of the elements of the composite peril that we see in the closure clause in our policy. And then on the right-hand side, we have the prevention of access clause, clause 7. Prevention of access by a public authority. We will pay for loss that results from an interruption of your business that is caused by any legal authority preventing or restricting access to your premises, or ordering the evacuation of the public as a result of damage to or threat of damage to property or persons within a 50-kilometre radius. So you have, on the left-hand side, a specific clause dealing with closure for very specific reasons, including the outbreak of infectious or contagious disease, and then on its face, a much more general clause, clause 7, dealing with prevention or restriction of access, and then including as a result of damage to or threat of damage to persons within a 50-kilometre radius. Now, the issue is set out firstly in Justice Jago's judgment, which you will find at page 1666 of the bundle, in paragraph 561. So the issue is, does clause 7 that we've just been looking at extend to diseases? And the conclusion is stated in the first sentence of paragraph 561 of Justice Jago is that as a matter of construction, in the context of clause 8, I consider that clause 7 does not apply to disease, which are instead regulated exclusively by clause 8. I reach this conclusion on the basis that the operation of the policy would otherwise involve profound incongruence and incoherence, and not mere redundancy or tautology. And then could I just invite the court to read on the rest of 561 all the way to the end of 564, please?
Well, that's all reproduced in your submission, I think.
I think most of it is, but and if it's familiar, if it is all very familiar, we can go to the full court.
Yeah, please proceed.
So and then the full court endorse this analysis at we see that at 1941.
1941.
Bundle.
1941.
And this is the judgment of Justice Mashinsky even, and that's paragraphs 17 and 18. saying the primary judge, the key issue in the appeal is whether the primary judge was correct to hold that Clause 7 didn't apply to diseases. And then the analysis goes on in paragraph 18. In my view, the primary judge's construction of these clauses is the correct construction for the reasons given by Her Honour. In particular, if Clause 7 were construed as applying to an authority preventing or restricting access to the premises where the threat of damage to the persons is from disease, the requirements in Clause 8 for an authority to close or evacuate premises as a result of the outbreak of disease would be circumvented. B, the 20-kilometre radius would be circumvented, and the 50-kilometre radius in Clause 7 would apply. And then C, the limitation in Clause 8 to infectious or contagious human disease would not apply. And then D, the exclusion of highly pathogenic avian influenza in Clause 8 would not apply. In light of these matters, construing Clause 7 as applying to an authority preventing or restricting access to the premises where the threat of damage to persons is from a disease would result in profound incoherence or incongruence, as the primary judge concluded. It follows the primary judge was correct to conclude that Tap House was not entitled to an indemnity under Clause 7. Now, pausing there, obviously, we say the parallels are striking here. And in terms of those reasons that are relied upon in paragraph 18, we've got A, the requirement in Clause 8 for an authority to close or evacuate the premises as a result of the outbreak of a disease would be circumvented. Well, we say the same is true if the LOA's clause in our policy is construed as broadly as the Court of First Instance construed it. Well, then the requirement for one of the particular closed set of reasons to be engaged is circumvented. Then we've got the radius point at B in the Marrickville decision, paragraph 18b, the 20-kilometre radius would be circumvented and the 50-kilometre radius in Clause 7 would apply. Well, here we have different radii that apply in the LOA clause and in the closure clause. So again, there is a distinction, and that is a relevant consideration. And the C and D are effectively are the same sorts of points going to, well, you've got these particular requirements for closure in one clause. We've been through the 6 requirements in the closure clause, and we say it cannot be the party's intention to have simply said, well, you know what, you get exactly the same 25 million dirham of cover, irrespective of whether you can satisfy any of those requirements or not, under limb B of the loss of attraction clause. And that is what is meant by incoherence or incongruence here, is what on earth is the point of saying you get cover for closures in these particular circumstances, and then saying, well, that all just goes out the window and you get the same level of cover, exactly the same 25 million dirham of cover, irrespective of whether they're satisfied or not. And we say that is an uncommercial and wrong construction of the policy. For completeness, I should also just point you to the relevant passages from the judgment of Justices Derrington and Colvin. That's at 2116 of the bundle, so you have it for your reference. And it's paragraphs 519 to 524. And if one looks at paragraph 521, which is at 2117, here the justices unpack in the way that I've sought to unpack the 6 requirements under the closure clause, the various requirements or the various limitations on the cover in Clause 8 in a bit more detail. And they go on to say in 522, in neither its written submissions nor oral address was Tap House able to provide an adequate explanation as to how these difficulties might be ameliorated. And we say the same is true of Lals here. The only answer that's really given is, well, yes, these clauses just operate on a freestanding basis, and that's it. And it's a pick and mix policy. And if there's conflict, well, and incoherence and incongruence as a consequence, well, that's it. And we say that that is not the correct approach as a matter of law. One doesn't just, when one sees the conflict and the incoherence that's generated by a particular construction, one doesn't just shrug one's shoulders and say, oh, well, that's it then. Unfortunately, the court has to make a bit more of an effort and say, well, actually, is there a more general clause and is there a more specific clause? And can we read this in a harmonious and coherent manner? And that's what we are inviting the court to do in this appeal. And Lals seek to distinguish, I've already touched on this, Lals seek to distinguish Marrickville principally on the basis that the court didn't want to give, I think it's described as an unnaturally extended meaning to the term damage to persons in the prevention of access clause. But as I say, we're not, of course the clauses are differently worded. We're not trying to say that, yes, you just transplant, that you can just transplant the analysis because word for word they're the same. But on any view, we say, the similarities between the clauses are extremely striking. And the analysis that underpins giving preference to the specific over the general is a general principle in the common law. And it is a principle that is reflected in the DIFC contract law as well. So we say that simply saying, oh, well, the wording is slightly different, that's going to take you nowhere. We rely on the analysis which we've taken you through in writing and reminded you of now, and say that unless the clause, the LOA, the general LOA clause, is read down, it does result in this exactly the same sort of incongruence and incoherence that the both Justice Jago and the full court in Australia was aiming to avoid in Marrickville. Now, the second case I wanted to take you to, if I may, is the award of Lord Mance in China Taiping, and this is by way of contrast. And again, if one turns to page 718 in the bundle, paragraph 35 of our skeleton, we set out the two clauses in China Taiping side by side. And we have a closure clause on the left-hand side, extension 2, and a denial of access clause, extension 1, on the right. And again, these are BI extensions, similar to the sorts of extensions that we're considering in our case. And just dealing with the closure clause first. Section 2, so that's the BI cover, is extended to include interruption of or interference with the business commencing on the first day of any such interruption or interference in consequence of the occurrence at the premises, and then colon, and then there are various specific things identified. So A, we've got murder, suicide, food or drink poisoning. B, infectious or contagious disease. C, vermin. D is then, so that the A to C are the specific elements of the peril, and then there's a requirement at D which causes restrictions on the use of the premises on the order or advice of the competent local authority, and then E is about damage to the drains or sanitary apparatus, and then there's a classification at the bottom of the meaning of notifiable human infectious or contagious disease. So that's on the one hand your closure clause, and then on the other you have your denial of access clause, which is equally verbose and detailed. Section 2 is extended to include interruption of or interference with the business in consequence of damage to the property in the vicinity of the premises, which prevents or hinders the use of the property or access thereto, provided that the cause of the such damage is not excluded. And then a B closing down or sealing off of the premises or property in the vicinity in accordance with instructions issued by the police or other competent local authority for reasons other than the conduct of the insured, or any director or partner of the insured, or the condition of the premises, or the carrying out of repair or maintenance work at the premises, presumably by a competent authority. And then C, the actions or advice of the police or other competent local authority due to an emergency threatening life or property in the vicinity of the premises, provided that, and then there's some various exceptions to all of that. So the reason for taking you through that is the contrast between these clauses and the clauses in both Marrickville and in our case is, again, instructive. You have two very detailed provisions. And so when, as we will see, Lord Mance is presented with the same sorts of authorities that I've referred to about reading down the general in favour of the specific, understandably, his conclusion is, well, hang on a sec, these both look to be pretty specific to me. Which one would I read down? And so if one goes on to page 1287 of the bundle, we see Lord Mance's award. He says, paragraph 24, two very specifically worded extensions with potentially overlapping effect and different detailed requirements. It's hard to regard either as clearly more specific than the other overall, and so on. And then paragraph 25, policyholders point out the draft new extension 2 is far from perfect, and no doubt that's true. And then paragraph 26, clear there is considerable potential for duplication, and then he deals with some of the duplication that may arise. And then 27, extensions 1 and 2 therefore stand side by side, addressing, as I've noted, a number of potentially overlapping situations or situations with potentially overlapping elements. And the conclusion in I think that 28, for all these reasons, I cannot regard extension 2 as a specific provision which precludes reliance on extension 1 in circumstances otherwise within that extension. They must be allowed to operate according to their own respective terms, whether they contain elements which potentially overlap or not. There's no implied exclusion under extension 1, even in respect of notifiable diseases covered under extension 2, still less in respect of COVID-19. So the general principle is the same, i.e., if there is a specific provision and there's a potential conflict, then the general should be read down to accommodate the specific. But what Lord Mance is saying here is, in this particular case, where you've got much more detail, two very detailed provisions, there isn't one that you can choose to read down, and that's really what he's saying. So I think that's effectively what the court in Marrickville also gleaned from the award, as well as ticking off the advocates for referring to Lord Mance's award as an authority. And I think we see that at page 2115 of the bundle. Paragraph 513 of the judgment of the full court. The second sentence, as discussed here, the policy wording for his lordship was substantially different to the terms of the Tap House policy. Two very specific and structured clauses, neither of which might be regarded as more general than the other. And then the conclusion, such matters support Lord Mance's conclusion that in the policy before him, neither clause was clearly more specific than the other. And of course, in our case, Lim D of the LOA clause is clearly more general, less specific than the closure clause, which has those 6 requirements in order to engage cover. So we are just dealing with a very, very different case. The last authority I wanted to take the court to is the Irish decision in Brushfield. This is not really about specific versus general, this is in support of really of the construction arguments that I've already been making on the language of the LOA clause. And again, if one turns to page 716 of the bundle, you can see the two clauses that were being considered by the court. There's a denial of access clause, and limb 1 of that, actions taken by the police or any other statutory body in response to a danger or disturbance, etc. And then the what's called the MSDE clause on the right-hand side, and we will cover your business for any interruption by the section as a result of the occurrence of any of the following specified human infectious or contagious diseases. And then there's a list not including COVID-19, and then there's additional cover for murder, injury and illness, vermin, etc. So those were the two clauses that were really under consideration in the relevant part of the judgment. And then if we go on to page 1250 of the judgment, sorry, of the bundle, there it's really paragraphs 190 to paragraph 191 of the judgment, and the court here is dealing with the meaning of the word danger and the fact that it needs to be read in context, and the obviously there are various subpoints made in the following paragraphs, not all of which are relevant, but some are. So in A, the court is dealing with the meaning of dangers and the help one gets from the reference to the vicinity, and the fact that has a local connotation. And it goes on to say the same consideration arises in the case of the 1 mile radius, just at the end of subpara A. It too strongly suggests a localized form of cover. And so we say that fortifies our reading of the impact of the radius in the LOA clause on the scope of that cover being narrow and localized. B, the word danger is juxtaposed with the word disturbance, and that has a very localized connotation. And again, that's just another example of the court's reading one word juxtaposed with another and the meaning of the two influencing each other. And then C, the reference to actions by the police or by a statutory body is also important. As explained in more detail below, it seems to me that the use of the word such actions was intended to extend to measures which do not have the force of law, such as those that may be taken urgently to address an immediate danger before there's time to invoke specific powers. Typically that will arise at a local level, for example, members of the Garda may need to seal off an area where there is a building in danger of collapse or there's a bomb scare or an unruly protest. And again, this is just another example of the courts being prepared to scrutinise the wording of particular clauses and say, look, maybe at first blush, maybe on one reading, you could say that this has a wide general application to anything that happened in the pandemic. But actually, when properly scrutinised, you can see that it's actually got a more of a local feel. And we say you can reach the same conclusion for the reasons I've already elaborated for the particular wording of the LOA clause. So obviously, I've taken you to 3 of the cases. I may return in reply to anything my learned friend takes you to, but I'm not saying here that, again, to stress, the cases are obviously dealing with specific policies, but they are applying consistent, particularly when one looks at Marrickville and China Taiping, there is a theme that underpins them, which is about if you have the general clause and the specific clause reading down the effect of the general to yield to the specific. And we say that whether one looks at these 2 clauses as a matter of language, and I'm picking that they're really aimed at different targets, and or with the commercial considerations that I've identified, is it really likely that that first Venn diagram is what the parties intended? You went to the trouble of negotiating the inclusion of a closure clause with very particular requirements, and then said they're just irrelevant because you can get your 25 million of cover under a completely different clause. And we say that is not objectively what the parties are likely to have intended. And for those reasons, we invite the court to allow the appeal and to answer the preliminary issue 1.3 as follows: that the cover under the LOA clause is limited to business interruption losses following a specific local incident where law enforcement actually physically close or seal off the insured premises or a right of way, and that it does not respond to national or regional government responses to the COVID-19 pandemic in the form of lockdowns, curfews and the like, as the court of first instance considered that it did. So I have finished earlier than I anticipated, and that may mean that I have more to say in reply, but I don't know whether my old friend wants to start now or we take a half-hour break now and come back earlier. And obviously we're in the court's hands as to what it would like to do.
I would like to suggest we start, judges. I would like to suggest we stop now and start in half an hour's time.
Yes. I thought you said start now.
No. Stop now. Start in half an hour's time.
Jolly
Okay.
good.
Okay.
Right.
That's
We'll rejoin in half an hour.
I'm not going to. I'm just going to leave this screen here. I'll just sort of block out the video as well as the microphone, because I don't have to have the problem of coming back later. So I'm just going to turn off that. And
Okay.
okay, Josh. Okay, Mr. Walsh, I perhaps your argument can simply be put very simply that your argument is that the broad statement of the policy in one clause you were citing just now should be, as you used the word, should be read down by the more specific clause. That is your case, full stop. And you cited Machiavelli as your authority. Isn't it? I mean, basically that's your argument. To put in two sentences.
In a nutshell, Your Honour, you put it.
Yes, right.
So,
shorter than a nutshell. That's your case. That's your case.
it's my case.
Okay,
It is my case.
fantastic.
Your Honour has my argument, and I commend it to you.
Yeah, fantastic. Good. So now let's invite Mr. Dougherty to argue against that. Very simple argument.
Thank you, Your Honour. Perhaps it's helpful at the outset for us just to summarise Lals's position before developing the arguments, and I'd suggest there are four key points. The first is that the loss of attraction clause simply doesn't say what EIC wants it to say, and in particular, it doesn't say it's limited to where there is a specific local incident where the police or statutory authority physically seal up or close a particular premises. That requires reading in or writing in words of limitation, which are simply not there. The language, we say, is clear. There is no ambiguity. This is not a case where we get to choosing between rival interpretations. The second point is that there's in any event no actual conflict or inconsistency between the loss of attraction clause and closure clause. They are both quite capable of applying as the judge found. Third, insofar as this is intended to be something wider than conflict, there is no incoherence or incongruity, let alone profound incoherence and incongruity, in the overlap between the two clauses. Put simply, there's nothing uncommercial or unusual about there potentially being cover under multiple insuring clauses, any more than that it's unusual that one set of circumstances may result in breaches of multiple clauses under a contract. And the examples of China Taiping or Stonegate are simply examples of where there has been such an overlap. Now, exactly, they're simply examples, but what they illustrate is this notion that there's something inherently odd or uncommercial is not a good one. And indeed, the examples I give you are indeed recent ones in the COVID context. And indeed, EIC now explicitly accept that there is an overlap, dealing head on with the judge's point below, the inconsistency of the case being put forward. And we say, as soon as you accept that there is an overlap between the loss of attraction clause and the closure clause, it undermines the essential principle rationale of their case, and indeed firmly underlines the difference of a case like this from one like Marrickville, where the premise was that there couldn't have been intended to be any overlap, i.e. it was a binary choice on allocation within the subject matter between one clause or another. Now, EIC seek to suggest, and your honours have seen the excellent Venn diagram that my learned friend produced, which I couldn't hope to compete with, that there would be an almost total overlap on our case, yet on their case there might simply be a minimal overlap on their case. In fact, we say, in practice, when one looks at it, there would be an almost total overlap in most cases of murder, suicide, and food poisoning. And I'll come back to that point. Put simply, we say it's EIC's construction, even if it were otherwise open, which could give rise to the profound incoherence and incongruity. So we say that this is not a case where there is any oddity or incongruity in the submission that we put forward. Fourth, and in any event, even if there were a conflict here, the argument that the closure clause can be characterised as specific or more carefully calibrated, whilst the loss of attraction clause is general, is, we say, not correct on an analysis of the clauses. Indeed, when one looks at it, we say the loss of attraction clause is in many ways more detailed and narrow than the closure clause. And two, ignores the fact that EIC now accepts that the clauses can in fact overlap. So in short, we say the judge was entirely right to reach the conclusion that he did in his careful and well-reasoned judgment. Can I, at this point, perhaps just deal with the point raised about the standard on appeal in a case like this, on a question of construction? The answer is the relevant test under the DIFC rules, of course, is whether the judge below was wrong, assuming that there's no injustice. There's no injustice here. And similarly, this court is concerned in conducting a review. In questions of construction, I would accept that that would normally lead to a binary answer, yes or no. But, and I think this was one of the options posited, if the answer is, well, there are two equally available constructions, then it cannot be said that the judge was wrong. But this court has to conclude that the construction which the judge below reached was not correct, it was wrong. The only additional point that I'd raise, I think, is there is some guidance about the deference to be given to the judge below in the Australian case, which we have in the bundles, of McCain Insurance, which is at page 930. And it's McCann and Switzerland Insurance. And if we just take your honors quickly to that, the relevant page is at page 930 of the bundle under G11. And one sees under paragraph, or just above paragraph 33, general principles of construing the policies, and Justice Kirby sets out various principles. The one that is relevant to us in this context is starts at page 932, which is subparagraph 5, where, and perhaps I just invite the court to look at that, and in particular the second paragraph, which starts on page 933.
Yes, I can.
So one sees there the reference at page 933, second paragraph, to deference to be shown. I don't try and take it any further, but we do say in any event here, this is not a case where the judge was wrong. We say he was quite clearly right for the reasons that he gave. I'm obviously going to develop the points that I summarised at the outset, but in terms of the submissions, the structure I propose to take is to start again by looking very briefly at the policy wording, always a good place to start, and then make some brief submissions as to the proper approach to construction under DIFC law, before finally then turning to address EIC submissions on the proper scope of the construction of the loss of attraction clause and closure clause. But turning first to the question of the wording of the policy, Your Honour's obviously already been taken to it, and the judge analyses the key clauses in his judgment. I just want to bring out 4 points at this stage on the policy. And if we perhaps bring up the policy, which starts at page 546, we can see that this policy, structure-wise, is based on the LM7 wording. We can see that if we look at the schedule in the middle, policy wording, property all risk policy wording, LM7, London Market 7 wording. That provides the backbone for this policy that, as my learned friend said, is then added on to by means of various extensions, and in particular adds on business interruption cover. Whilst we're on page 541, we can also see under the reference to policy wording, we see the reference to territories, Bahrain, Kuwait, Oman, United Arab Emirates. I underline that simply to make the point that this is a policy applying to various GCC states. And it's a point my learned friend alluded to, that this has the result that when we're looking at certain specific phrases, for example, police or statutory authority, it shouldn't be looked through the telescope or technicalities of a specific jurisdiction, but more generically. Certainly not the telescope of England or Australia or Malaysia, but of GCC states more generically. Moving on, as my learned friend, I think, accepted, this is not an off-the-shelf policy. It's certainly not one we can see this has been drafted in a unitary fashion. It is, as we see from the reference to the extension clauses, which start at page 541 and then go on for 6 or 7 pages, essentially a bespoke cover prepared as between brokers and insurers. And we say that's relevant when you come to the question of how you would expect these terms and these extensions to fit together. The second point to make, and this is really a negative point, but it's one worth underlining anyway, is that the policy expressly provides for certain exclusions and exceptions. And one can find the first set at page 547, which lists a series of exclusions. In particular, there's no disease exclusion, and a list of exceptions, which start at page 554. So this is an example of the policy carving out, excluding certain elements of the policy. But what it does not do is do so either for disease or to say, for example, that there is certain terms are to have priority, as some insurance policies do, or carve out cover so as to ensure that they can only fall within one insuring clause and not another. As a matter of interest, although it's not directly relevant, but it does overlap with our clause here, there is in fact an exclusion or an exception here for vermin and fungus. And one will recall that vermin is covered under the closure clause. And if one looks at page 555, 3F, there's an exclusion there for a variety of things, including contamination, pollution, etc., but includes a few words in vermin. So this would be an example of where clearly the loss of attraction clause would not cover vermin. But it would be covered, of course, under the closure clause, which expressly deals with disease because it's expressly stated. That is an example of the special and the general, which I would accept. Now, I highlight this because as Lord Mance...
Excuse me, please teach me English. Vermin, is COVID a vermin? No.
But vermin would traditionally be something like rats.
Ah, that's what I thought.
Yeah.
That's what I thought. Okay. Okay, then please continue.
So the point I'm making here is that there is an express carve out for certain things, but not a carve out that's relevant specifically for the underlying perils we're referring to here. And as I said, I highlight this because the point that Lord Mance made in the China Taiping case, it's the point we highlight in the skeleton, is that an obvious way to avoid overlap between clauses would be to exclude it in one clause and make that clear. And then the reasonable policyholder looking at the policy would know what they were getting. That is not something that's happened here. As I said, it's a negative point, but it is a point we say that's relevant when one comes to approach the question of construction as a reasonable policyholder, or indeed a reasonable person. I don't think there really is a difference in this case. Would look at the question of what is covered and what is not covered. The third point to highlight is that the relevant limits of indemnities here are cumulative. They stack up. Each insuring clause sets out the limits separately in the schedule. So if we go back to the extensions under business interruption, page 545, under section 2, one sees, and I know your honour's already seen this, different references to limits under each of the business interruption clauses which provide cover. So 10 million for customer extension, 25 million for closure due to vermin, murder, suicide, infectious diseases. Further down, denial of access, 25 million, public utilities, 25 million. Over the page, loss of attraction, 25 million, any one occurrence, and in the aggregate with a 48-hour excess. I'll come back to that. So there is a separate limit for each of them, and we can be clear about this because if we turn to page 549, which is the main insuring clause as subsequently amended, headed combined material damage and business interruption policy. And there's a reference there, a few paragraphs down, in respect of section 1, and then we get to in respect of section 2. And there's the reference to the scope, and then it says then the insurer will, then in the middle of the page, then the insurer will pay to the insured in respect of each item in the schedule hereto, the amount of resulting from the interruption or interference in accordance with the provisions therein contained. And similarly, if we go to page 585, which is clauses applying to both sections, that's sections both 1 and 2. We can see that on page 584. If we turn back to 585, costs and additions, insurers agree that the limits stated in the policy under each extension and clause are payable in addition to the amount of the insured claims for loss and damage. And there's no overall aggregate as between the individual clauses. There's a sum insured overall. There are provisions in relation to the various policies of insurance, but there's no overall aggregate as between the insurers. So it's not saying any business interruption loss maximum is X. And that's why the Lals' claim is put at, I think it's 70 million or so. The loss is said to be greater than the limits of indemnity, but they are stacked up. And certainly as we've understood it, that's not disputed. If one looks into defence, it's not a point that's taken that they don't stack up. There's obviously no admission that there are any actual losses that trigger it, but that's not been an issue. And indeed, that's why we're here. Why did it make a difference if we already have cover under the loss under the closure clause, assuming we can establish the cases of COVID within the area? Reason because these are levels of cover that stack up on top of each other. And as we say in the skeleton, I mean, that completely answers the redundancy argument. The question of what purpose is there for being covered under two clauses? Well, because you get the benefit of extra limits. Now, in some policy, that's not how they work. In some policies, there will simply be a single limit that applies to all the extensions. Or even if they're separate limits, there is a underlying aggregate, which means it's effectively any one claim in the aggregate overall for all the extensions. But that's not the position here. That's the basis. That's why we're having this argument. Fourth, as the judge noted, this is, to be kind, this policy is not a model of precision. There are countless examples of inconsistencies in expression between clauses or formatting or numbering, which has gone awry in this policy. But focusing just on the business interruption clauses, and if we turn to page 580, where we see the closure clause. If you look under the closure clause, you'll see that there's the reference there to the insured's business premises. There's first a reference on the second line to insured's business, then 4 or 5 lines, there's a reference to the insured's business premises. And if we look at the definition of authorities, 3 lines down, we see reference to national health authorities, competent government, public or statutory authorities, all capitalized, suggesting that they are defined terms, which they are not. And if we compare that with the loss of attraction clause 2 pages on page 582, we see the reference to insured business premises not there. Instead, what we see is reference, for example, under A to insured locations. In fact, that's used in A and in B and in D, and under the calculations under 1 and 2. In B, and again, that's referred to sorry, that has capitals on it, which suggests a defined term, which again, you would struggle to find in the policy because it's not a defined term. Under B, you'll find premises completely capitalized, which again might suggest a defined term, but again, you wouldn't find it. But whilst those things are capitalized, if you look at statutory authority or police under D, they're not. Similarly, and just a bit more broadly, if I could take the point quickly, one can see sometimes the policy refers to insurers as insurers. So, for example, if one looks at the interdependency clause on page 581, third paragraph, page 581, nothing contained in this clause shall increase the liability of the insurers, defined term. But if you turn back to page 580 to failure of the public utilities, instead of a reference to insurers, if we turn the page, we see a reference to the company. So page 581, 4 paragraphs down, provided, however, that the company, i.e. insurers, shall not be liable for any consequential loss, A and B. In fact, A, there isn't even a B. So to say, put it kindly, this policy is not the product of elegant and coherent drafting. It has all the hallmarks of being cobbled together from various sources, where, for example, there were defined terms. It is, I think my learned friend accepted the reference, a pick and mix type policy. That's not unusual. There have been references to these being pick and mix policies, in fact, in 2 COVID cases this year in England, which I refer to in the skeleton, the Bellini case of the Master of the Rolls, Sir Geoffrey Voss, and the Gatwick case. The relevance of them being pick and mix cases, and it's the point picked up by the judges in those cases, it makes the fact that clauses overlap or that clauses on their whole may not have any content unsurprising. Don't expect seamless drafting if it's not the product of a unitary exercise, but instead the product of the pick and mix exercise I've just described. And we say all of that is inconsistent with the suggestions that the parties must somehow objectively have been taken to have intended one of these extensions to take priority over another, or for them seamlessly to fit together so as to avoid any possible or theoretical overlap. So those are the points I wanted to make on the...
But when one talks about objective intention, you're talking about intention determined by reference to the preferred construction. It's not an antecedent reality, is it?
No, I accept that, but it is a question of looking at what you would draw from the policy as a whole. And where you have a unitary policy, drafted in a unitary way, a standard form, you may have different expectations of what you expect in terms of precision. It's a point made, I think, by Lord Neuberger in the Arnold and Britton case, which Lord Mance sets out in the China Taiping. It's context specific, and there's the danger of applying assumptions that may or may not be right for a standard form policy, but may be less appropriate in the context of this type of policy.
So you accept the objective intention might be a bit confused.
Well, I certainly accept that it may be less elegant than one would want it, but in a way, what my learned friend seeks to draw is a general assumption that when policies are drafted, that they must be coherent. And whilst I don't doubt as a general principle that is one of the principles that can be applied, it is, as Lord Neuberger makes clear in Arnold and Britton, always going to be context specific. And I'm about to come to the question of construction generally under DIFC law, but it's part of my broader submission, which is one has to be careful about any of these canons of construction and elevating them into something and giving them a role where perhaps they have less of a role. So, Your Honour, turning then to the question of construction under DIFC law, and I hope I can deal with this relatively briefly. I obviously heard what my learned friend said about not challenging the judge's primary approach to what the relevant principles were, really just challenging the application of it. I would commend the judge's summary of the principles at paragraph 21 to 31 of his judgment, including his reference to the well-known helpful synthesis of Lord Hodge in the Supreme Court, UK Supreme Court case of Wood and Capita. As I just alluded to, I'd also, if I may, I'm not going to take Your Honours to it at this stage, commend the award of Lord Mance as providing another useful summary of the relevant and I think uncontroversial principles at paragraphs 13 to 18 of the award, and that's page 1281 for Your Honour's notes. And the essential point, of course, is well settled. The key question is the objective meaning of the language actually used by the parties. EIC, for the purposes of the appeal, obviously has sought to rely on various canons or guides of construction, and these canons all essentially seek to embody common sense. They won't always, in fact, point in the same direction, but I certainly again accept that they can be helpful in trying to understand what was intended by the words used. But again, it's important to remember that they are exactly that. They're guides in ascertaining the objective meaning of a contract. They simply exist to help, not to dictate. I think as Lord Justice Aiken said in a case once, they're servants, not masters, but that's their role. And that is the context in which one should be approaching them. Now, I don't think I need to turn up the specific provisions of DIFC law. The judge referred to them, which embody the primary objective approach endorsed by this case by this court in cases like Damac Park. You look at the plain ordinary meaning, and if it's unambiguous, you apply it regardless of commercial result. We deal with that in the skeleton. I will just touch upon the two specific provisions my learned friend refers to, and I think I can do it without turning them up, albeit if Your Honours want to look at them, they're on page 756 of the bundle. The first is section 51, that regard shall be had to all the circumstances, including the nature and purpose of the contract. I'd make the point here that the context that we're talking about in this here is a business all risk policy with business interruption cover and extensions. So we would say if ambiguous, one wants to avoid an interpretation which has the effect of removing aspects of business interruption cover. But certainly 51 is an example where things point in different directions. 52 and the reference to interpreting everything in the light of the whole contract or statement, again, an uncontroversial proposition. But again, it's important to recognise that it's not saying that all terms need to be given a consistent meaning. And indeed, my learned friend makes that point in his skeleton, where he says, well, actually closure and the closure clause and the loss of attraction clause should have different meanings. It simply means that you've got to look at the whole contract when you are trying to reach a conclusion as to what it means. It doesn't tell you what the conclusion of that exercise is. And again, what comes back to the well-known points made by, for example, Lord Neuberger in Arnold of Britain about it always being context specific, how helpful it is looking at other parts of the contract, how important context is. And finally, in terms of 53, which my learned friend refers to, namely all terms to be given effect rather than to deprive them effect, well, certainly we would say overall that the claimant's interpretation is one arbitrarily to diminish the effect of the loss of attraction clause rather than to give it effect. But I'll come back to that in my primary submissions. Turning briefly to the specific canons that my learned friend relies on, and I'll come to them in their application later. We certainly accept that where there is inconsistency or conflict, that the specific provision will generally trump the general provision, albeit, as the passage in Lewison points out, it will always depend on the ultimate wording used. But we do say there does need to be a conflict or an inconsistency. Otherwise, you should simply be applying the contract. Otherwise, you are carrying out an inappropriate exercise where you are depriving the clauses of meaning and effect. The justification of the specific over the general can only be as a resolution where necessary between two terms that cannot sit together. If a clause says go left and another clause says go right, well, you've got to decide how they are to fit together, because if you can't, you have an invalid clause and possibly an invalid contract. And that we make the reference in our skeleton, for example, by reference to Lewison, to the eternity case, the dicta of Mr. Justice David Steele. It's also a point made in the Vogenauer commentary in the Unidroit, on which the DIFC laws specifically based. And I may just take, if I can just take your honours to that, that's at page 796. One sees their commentary of the Unidroit principles, international commercial contracts. And under 5, it's the relevant section on inconsistency in the contract or statement. And there is a reference there to examination contract can reveal inconsistencies between different parts. Such inconsistencies have to be remedied. And if we go down towards the middle, sorry, a few lines down, as a general rule, there is no hierarchy amongst the different parts of a contract, and the respective importance of different terms are the same, unless the parties have established a hierarchy. There are 3 exceptions to this rule. First, in cases of conflict, more specific provisions take precedence over more general clauses. That's the context that we're talking about here. Now, that's a situation where you have clear language where they conflict, and you need to have an answer to the conflict. The second position is where, in fact, the language is ambiguous. Where the language is ambiguous on the 2 clauses, I certainly accept again, the court can there choose to prefer the more reasonable or harmonious interpretation over another interpretation. But that only arises where there is ambiguity in the relevant language. So they are different principles, and in my submission, it's important to separate out what one might say the proper conflict cases where they cannot sit together, and therefore the rule applies to give one precedence over the other, and the second position where maybe they don't sit very well, there is an oddity, but if the language is clear, then they should simply both operate. If there is ambiguity, then I accept commerciality, reasonableness, and coherence becomes relevant. The other principle my learned friend refers to, and did so a bit on the language arguments about pulling together statutory authority with police, for example, is the principles of nocitur est socius, the interpretation by your associates, and a justum generis of the same kind, considering terms by reference to the same kind. I think, again, we give the reference in our skeleton, but if not, it's G16, page 1073, paragraph 67, which is an extract from the Financial Conduct Authority Divisional Court decision. We don't need to turn it up. It simply makes the point that this is simply an example of a primary principle, which is to read contract in context. So I don't doubt the point, but again, it is not a slavish rule. It is simply a canon which can assist in suitable cases in terms of understanding meaning. And the final point that I make, and again, I say this hopefully uncontroversial, but it is that courts should not undervalue the importance of the language used in terms of trying to find ambiguity, nor search for infelicities or uncertainties so as to depart from natural meaning. And that's one can find again in the passage of Lord Newburgh and Arnold Britain, which is set out in the Lord Mance judgment in the passage following 1281, paragraphs 13 to 18. Again, I don't bring it up. I hope it's uncontroversial. The exercise is to faithfully interpret the language, albeit in the context of the policy as a whole. Finally, on the question of the perspective that's to say the reasonable policyholder or the reasonable person. There's no dispute here that we're looking at the reasonable policyholder in terms of the guidance, and my learned friend doesn't seek to quibble. He perhaps queries as to why one's got to that position. And if one has that question, there are a number of answers as to why the English court has got to that position. But the important point is, in fact, it's very unlikely to make any difference in terms of what the interpretation is, other than perhaps to particularly emphasise the need to be wary about overly technical or artificial constructions or arguments that the policyholder reading through the policy, with the assistance of a broker, wouldn't spot. And if one's reaching a conclusion where one thinks, well, that's not a conclusion that the reasonable policyholder looking through this policy would have got, then something has gone wrong, because whatever has led one to that conclusion has taken one away from the primary question of objective construction as seen by the reasonable person in the insurance context as objectified by the reasonable policyholder.
But if we were to prefer the view that the construction goes to determined by attribution the objective intention of the parties, then you say it doesn't make any difference to your arguments ultimately.
Perhaps this is the time just to explain why we say the English courts have got to this position. And I think there have been two explanations given. The first is the one that Lord Mance gives in the award, which is that the reason you look at it from the perspective of the reasonable policyholder is because the document is addressed to the reasonable policyholder and is intended to be objectively intended to be comprehensible or digestible by them. So that's the perspective. So that's the first point. There is another reason that's being put forward, and again I think we refer to the reason, if not the case, in our footnote of our skeleton, which is essentially in this context the policyholder represents the lowest common denominator. If one's looking about shared understanding between an insurer and a policyholder, and we're trying to understand what the relevant shared understanding is, the insurer will almost inevitably in insurance context have a broader perspective, a broader understanding than the policyholder. Therefore, effectively, the policyholder stands in place. That's, I think, a point. I'm probably butchering the example given, but I think that's how Sir Richard Aikins explained it in a recent award in England. Again, another public award in the Salon Gold.
Might be appropriate if you're talking about household insurance or fire and accident, but when you're talking about sophisticated parties of your client's magnitude and an insurer, one doesn't have to put a kind of consumer protection overlay on interpretation.
Well, I think the answer would be it's not a consumer protection overlay. It's focusing on where the relevant focus is, and of course, if it's a more sophisticated policyholder, that's the relevant answer. But as I said, in this case, we don't say there's a difference. So the relevant point, and this is perhaps a key point, is who you can dispatch easily is the pedantic lawyer. That the clever, technical, artificial argument where one says, aha, if we do A, B, and C, you can trump this in some technical way. That is when you get into artificiality, and it's why quite an important point of the judge's final conclusion on this issue, you'll recall, is that he ends up by saying it's not how he understands a reasonable policyholder would have read the two clauses. And whatever conclusion this court reaches, we would respectfully submit that in a way that is the ultimate litmus test. One can apply the canons as assistance, but if one is reaching a conclusion that one says the reasonable reader, and whether one calls the reasonable reader the reasonable person or the reasonable policyholder, would not have found, then we would suggest that something has gone wrong. Your Honours, can I turn then to the specific arguments raised in terms of the scope of the loss of attraction clause? And I think it's fair to say the focus of the EIC's argument has somewhat shifted. Initially, I think it's right to say the main focus of EIC's case below was on the language of the loss of attraction clause. And indeed, that's how it's pleaded. If one looks at the pleading, one sees nothing about coherence of the clauses, etc. Now, the focus is very squarely as shown by the grounds of appeal, that it renders the carefully calibrated closure clause redundant. I'm not making any sort of technical point, other than it is a recognition. I think there was a little teasing out of my own friend, a recognition that but for the existence of the closure clause, there would almost inevitably be cover under the loss of attraction law, and that's the only actual ground of appeal that's set out. But I'm obviously going to deal with the language used first because my learned friend does still rely on it, and also more specifically because it positively asserts our case. It's not a sort of neutral point that the EIC doesn't get over it. What it actually shows is that the construction which my learned friend seeks to put on the clauses is, we say, simply one that isn't reasonably open. So let me start with the ordinary language or ordinary meaning of the language used in the context, obviously, of the policy. Now, perhaps the relevant clause is the loss of attraction clause at page 582. And we see there that the phrase is a reference to closure under D or sealing off of the insured locations or any right of way by the police or other statutory authority. And as my learned friend took you to the preliminary issue, and in particular, the relevant question is whether this clause only responds to a specific local incident, where the police or statutory authority physically turned up to seal or close a particular premises, or, as the judge concluded, can encompass closure responding to a global pandemic. So EIC needs to say we need a specific local incident where you seal up or physically close particular premises. Now,
well, the question, just looking at the question, second limb of that, whether it responds to a national or regional governmental response to a global pandemic. That must be read in context as referring to closure following on from some response to a global pandemic by a national or regional government, mustn't it? I mean, it has to have an endpoint which impacts and creates loss.
You're quite right. I think what's fair is really this was again, it's not pejorative, but this was a negative preliminary issue. It was about not answering the question as to whether there in fact was a statutory authority which had done something, but that was for another time. It was really to say, well, actually, can we say this is so narrow that it will never apply? And so the latter is really leaving the point open for what is the statutory authority, but saying, well, actually, we never get there because on our interpretation, this is inherently local and requires physical presence and all the other specific elements, specific local instance where physically closed particular premises. And the core complaint, indeed, the judge recorded me saying this, is that we say EIC focused on what the clause must have been envisaging or must have been mainly focusing on rather than on what the words actually say. The interpretation really turns it into a trap for the unwary reasonable policyholder or reasonable reader who won't get what he thinks he gets by the extension on their plain language. Now, going through the specific points.
Sorry, I'm just trying to understand the answer given to 1.3.1. Are we saying that, is that to be read as saying that the loss of attraction clause is capable of covering a sealing or closing up done pursuant to a national or regional governmental response to a global pandemic? In other words, suggesting a causal connection between the closing up, maybe a legally causal connection to the closing up, and something that is done at the national or governmental or regional government level.
Yes, in the generic. So it's accepting the principle that it could apply. So that because the key aspects, Your Honour, of these disputes, certainly after the divisional court's analysis in England, was this notion that some policies were focused purely on what was happening locally. And so if something was happening locally and nationally and globally, then in fact the clause was effectively saying, well, that's not covered. It's effectively excluded from the scope. I mean, and that was approach of the divisional court for some clauses, saying they are inherently local. And as Your Honour may or may not have seen from the Supreme Court in the division in the FCA test case, they reversed that and said, no, it's right that you need to have something happening locally for these clauses, but that doesn't tell you necessarily whether there is causation or not, because of the approach to concurrent causation. And subsequent English cases have worked out, therefore, what the impact of various answers that were given in the divisional court. So that's a long way, Your Honour, of perhaps not answering your question, but of explaining why there was this dichotomy between what might say the local and the global.
Well, I'm just my concern was about the construction of the answer. So, for example, in Western Australia, we had a statewide lockdown, and you could go from your house and walk for certain times a day or for a certain period of time, but nobody came and sort of posted policemen outside your houses or outside the shops and restaurants. But if you have an area from which by a national prohibition nobody can enter into or leave that area, which includes your client's premises, which say 1 kilometre, but within that area, that answers the second limb of that answer, does it, of the response? Yes. On your case?
Yes.
Yeah, so there's a national prohibition order and it works on your location.
Exactly.
And if you go to leave, you might run the risk of some policeman coming and stopping you.
Yes. So if it says, I mean, if there's a national thing saying all retail needs to close in Dubai or in Abu Dhabi or in Kuwait, and obviously different territories here, then that is sufficient to amount to a closure by a statutory authority. It doesn't require, as my learned friend would say, well, actually, it has to be something focused on a particular premises, one premises, and a policeman going there, closing the door or putting cones outside. But that's simply not what this clause requires. It may be examples of what it includes, but that's quite different from what it requires.
Yeah.
So, returning to the clause on page 582 on the loss of attraction clause, the first point to note is there is nothing in the wording which says it has to be a response to a specific incident, let alone a local incident. Those words are entirely missing. It is, as the judge said, simply results based. The question is, has there been a sealing off or closure? The reason for it is irrelevant. There's no need as such for any incident or event or occurrence or danger or disturbance or different language that is used in other clauses. It may well be that a classic or paradigm example is a road accident outside your house or a gas leak. But as the judge said, relying on what Mrs. Justice Cockrell said in the Corbyn and King case, you don't construe clauses by reference to their paradigm. And that's in my submission, it's a key point, because there is every difference between saying, well, in lots of insurance clauses, it's a fire policy and a home policy. There may be typical examples of how a fire will start, of what people had in mind, the discarded cigarette. But there may be other cases which are completely unusual. You know, the meteor that happens to crash into your house and cause a fire. Now, that may be excluded, but if it's not excluded, the fact that it's very unlikely, it's not what you were normally expected, doesn't stop the fact, if it's caused a fire, that you would have cover for your fire policy. And that's the essential point, that here you're simply looking at, was there closure, was there sealing off by the police or statutory authority? If you have, then you've satisfied the requirements, subject to obviously satisfying the 48 hours excess, which I'll come to in a minute. And in a way, that's it. My learned friend referred to Brushfield, and I can deal with that. The judge dealt with that, and we deal with it in our skeleton. But let me just make the points very briefly. It's not a case we say that assists at all. Why? Because the language, which in that clause, in the Brushfield case, was very different. So when the judge concluded the importance about locality in Brushfield, he had a clause before him which referred as a trigger to cover there needing to be danger or disturbance within 1 mile. That was the language that was being used in that clause. So it's obviously very different from a case where there is simply no requirement for any incident at all. The second point on Brushfield, again, we deal with this in skeleton, is that it is a case that where the underlying reasoning was considered and distinguished by Mrs. Justice Cockrell in the Corbyn and King case. And in particular, the criticism that we say is a fair one, which the judge below accepted, was that the approach to construction was one based on paradigm or general examples rather than conventional instruction focused on the actual language used. And the judge accepted that following on from Mrs. Justice Cockrell's decision. Interestingly, as you will have noted, the Corbyn and King decision had exactly the same wording as the Brushfield Irish decision. They were the same clause, but Mrs. Justice Cockrell took a different view, and one which the judge rightly, in my submission, took a different view on. But as I said, in some ways, what could be overwide about it, because on any view, it's a very different clause, because it requires something to have occurred, a disturbance or a danger within a radius, whereas this one is not event based. Turning then to my learned friend's reliance on the radius provision in the loss of attraction clause. As the judge said, there is in fact no overall radius provision applicable in this clause. So although the schedule in this case, the extension refers to a 1 kilometre radius, it's apparent that that 1 kilometre clearly can't affect every part of the clause. Clearly, it's not going to affect the parts of the clause which refer to at the premises. It's not going to affect clauses which don't have a specific place. And the example the judge gave was extremes of climate, a heat wave, a storm that doesn't have a specific location as such, or localized location, doesn't carry with it. And indeed, we say it doesn't apply to subparagraph D. What it applies to, we say, most obviously, is it is a replacement for the word vicinity in the clause of loss of attraction. So if your honours look at the loss of attraction clause, you'll see that under A, it says loss or damage to property in the vicinity. In subparagraph C, the presence of a suspected or harmful device in or in the vicinity. Now, vicinity is obviously a word of uncertain scope, and the English cases have had to deal with the question of, well, how far is a vicinity? And the answer is it depends. And for example, a harmful device, if you have a small bomb, the effect may be quite small. If you had some sort of nuclear device, it may have a much larger relevant vicinity. It is a flexible concept. What the 1 kilometre does is provide certainty, we would say, in changing something uncertain, unclear, to something of specific geographic ambit. It doesn't have any role more widely. Now, the relevance of all this, and the answer is it's probably not a very relevant point either way. The relevance of all this is to say that this is not a clause which one can say, well, it's inherently local. No, it isn't inherently local. There are local elements of the clause, just like the closure clause, things like murder, suicide, food poisoning, also has inherently local elements, things that will happen in a specific place. But it's wrong to say that the loss of attraction clause generally is purely a localized a cover, form of cover. I should say the reason why I can't get too excited about this is that even if it did require a local incident within a radius, in circumstances where EIC accept the Supreme Court's approach to concurrent causation, this wouldn't preclude cover, even if there was even if the closure was caused not just by a case within the 1 kilometre, but also by cases elsewhere. That's the concurrent causation point. And again, that's the point Mrs. Justice Cockrell makes in Corbyn and King, that the mere fact that you have something has to happen locally doesn't mean it only responds where there is a local incident as opposed to a global pandemic. It simply requires there to be something local, not for it to be solely local. Turning then to the word police, which my learned friend also refers to as part of the overall phrases, we certainly say that doesn't have any local connotation. It's certainly in the context here, as the judge noted, all the forces in the GCC, which are in the named territories, were either national or Emirati forces. And that's different from the English position, where obviously you typically have more local forces. And again, it's not been a particularly successful point in England either. But certainly in this context, the argument of locality and police does not work, we say. Turning then to the phrase statutory authority, I've made the point already, I think my learned friend accepts, certainly for present purposes, that this is something which has to have a broad non-technical meaning, given the multiple territories involved. It's clearly very wide, we say, on an ordinary meaning. The judge below referred to it being naturally read widely. We respectfully agree that is the natural reading of statutory authority, has a broad concept. And yes, we do pray and aid the fact that the English courts on looking at statutory authority have referred to it as, and we set this out as wide, as a wide proposition, and that the agreements, for example, in the FCA test case, specifically included UK government as being a statutory authority. Now, none of these are authorities for this court. That indeed, the declaration was a product of agreement between the FCA and the leading lights of the insurance world for the various insurers. But it reflects, we say, the simple reality. Statutory authority has a wide meaning. And this attempt to say, well, you need to read it narrowly, it is simply not one that we say is a good one.
So now, you would say it picks up anything exercising official power?
Yeah.
Whether it be statutory or...
I think it's obviously not... Yeah, I'd certainly say for the moment, obviously, I recognise that it's not for this court, just as the judge regulator, to decide the specific ambit, because there are specific authority. But what I would be saying is it's really by any body authority having force of law. You know, contrasting it, for example, with a private authority, a landlord, for example, has a right to close off access. That clearly wouldn't count. But it's a non-technical understanding of something, of an authority having the force of law. The precise technical understanding of what is a statute, what isn't a statute, the source of power, customary, statutory, constitution, that we say is not directly relevant. That may be an argument later, but it's not something that we would say would naturally be understood, certainly when it's been used generically for lots of different territories. But I think well, on the point about the judges, my learned friend made the point, well, you can't take too much from the fact that the English judges have looked at the point and reached a different conclusion because it was all very narrow and not really considered. Well, the propositions are there. I'll take your honours to one passage just to make good one point. But the point I'm really making here is this was ultimately all pretty obvious to everyone, including the judge below. We have now 3 experienced judges who've reached a conclusive of a phrase. It doesn't bind, obviously, this court, but it's a pretty strong pointer that what my learned friend is seeking to suggest in terms of narrowness is one that is not right. If I can take your honors to the Corbyn and King case, just one short passage, and it's page 2244. And it's paragraph 183. And it's 183, 2244 at the top. Secondly, there is no locality limitation other than the radius. And then danger is not paired with local, nor is any relevant authority identified as local, etc., etc. While AXA contends that the wording for the authority tends to suggest locality, police coming first, it cannot escape from the fact the wording any other statutory body is manifestly wide enough to encompass central government. This was accepted in AXA's pleading, and its attempts to move away from this decision to gain traction, particularly in the light of the Supreme Court's declaration in paragraph 9, which makes plain the UK government is a statutory authority for the purposes of clauses of this authority. So I think my learned friend's point is, well, you know, there's not a huge amount of reasoning there. Well, with respect, we would say that's because there isn't really a huge amount of argument to be had. Ultimately, it is a naturally wide phrase. It also answers my learned friend's suggestion that the court didn't consider the juxtaposition of police. Mr. Justice Cockrell clearly did consider the point about police coming first in the context of locality, and so the sort of justum generis type argument, and found it wanting. And as my learned friend said, that's been followed in the Gatwick case. Your Honour have the reference to it, and we commend the reasoning. On the more specific point, so going away from the authority, just arguing the principle. On my learned friend's point of saying, well, they should take colour from each other, police and statutory authority. A list of 2 is not a promising start. It's not impossible to have a list of 2 and colouring each other, but it's not a promising start. And here the difficulty is that police are not a genus, it's not a kind. It's simply making clear that the police are included, because otherwise there might well be a dispute as to whether the police are a statutory authority or not. If one looks at the Gatwick case, one will see that, for example, in England, the powers of the police, of the constable, are traditionally common law powers, not statutory powers. It avoids that argument. It makes clear it's a classic example. I certainly accept that. That's quite different from saying it's reading it down or narrowing it. This isn't a case where the scope of the clause becomes absurdly wide if you don't restrict statutory authority. It's inherently restricted in its terms to statutory authorities which are in fact able to close roads or premises. It's already we would say, a narrow term. And if it did take any colour, it would simply be that it's an authority which has the power, like the police, to close premises or the road. And that would include local authorities, traffic authorities, the government. Powers with the executive authority to carry something out. Turning then to the point about reference to closure or sealing off, I do accept that sealing off can connote, or might well connote, a physical presence of turning up and putting a tape round or putting some cones round, but not necessarily. If, for example, there's a gas leak and the gas board says, you phone up the gas board and the gas board say, empty out the building, it would be correct to say, if someone asks why you're outside the building, to say, well, the gas board sealed it off. We're told to leave, we were told off. It's an expression. And indeed, that wider use of language is in fact exactly the language that was used in the China Taiping calls, which my learned friend took you to. That was a case of closing down or sealing off in accordance with instructions issued by the police or local authority. So stronger, I mean, closing down, one might say, is stronger than closing, sealing off, but the language added in is in accordance with instructions. Well, that's a natural use of language. That's the point we're making. It doesn't necessarily give you the answer. But in a way, all of that is unnecessary, and it's the point the judge makes, because when you get to the word closure, it plainly doesn't, in any natural, normal sense, imply someone attending to close. If the government gives you an instruction to close, that is clearly a closure by a statutory authority. I mean, the judge put it neatly when he said that the reference to by order or an instruction simply completes the chain between the statutory authority and the closure. And that neatly encapsulates the point. And indeed, Your Honour, Justice French's point, that actually in this context, a statutory authority would typically not be a natural person, really underlines the point that clearly it can't be envisaging the statutory authority itself turning up. And this all tells you that that's not what it's about. It's about the question as to whether there is the relevant link. It is nothing about physical attendance. Why were the shops in Dubai closed? They were closed by the Dubai government, or putting in extra words, by the order of or by the instructions of the Dubai government. That's the proximate clause. And again, the judge deals with this very well. I don't think I need to go any more detail. The judge also refers to the Supreme Court FCA case, which is the RSA 4 clause. This is page 1344, just for reference, where the reference was to enforced closure. And it was clear the court thought that enforced closure it included something which was an instruction. It didn't even need to have the force of law. It just needed to be mandatory. And the judge set that out. I don't need to go any further than that. But again, I commend that reasoning. And again, for completeness, because I mean, these are all simply examples, Marrickville itself, page 1679, paragraph 603, again, implicitly assumes that closure can be an order or a requirement. The language there was legal authority closing or evacuating premises. Again, no suggestion there that there was any requirement to turn up. Again, because it simply isn't the normal meaning. I mean, these are simply examples. They're not necessary, but I'm simply underlining the point. And again, there's no colour from any link with sealing off. Closure comes first, indeed, rather than sealing off. And clearly, it would make the closure completely tautologous to link the two and say it simply means turning up and actually closing, as opposed to an instruction. And then finally, on this point, this construction that EIC puts forward also envisages a different meaning to closure in the loss of attraction clause than in the closure clause, because the closure clause, of course, also refers to the word closure. And there, my learned friend entirely accepts that it does not require anyone to turn up. My learned friend says, well, words don't necessarily need to have the same meaning in the contract, contrary to his overall points about consistency. I accept that, they don't. And indeed, this is a policy which is has its pick and mix elements. But where it's an ordinary word, it's an unpromising start, and it's an artificial attempt to try and draw a distinction between the two words here, which simply isn't there. And the final part of this argument about the locality argument is the argument that it is all focused on closure or sealing off of particular premises, specific premises. But that, again, it's not what it says. And less than that, I mean, if one goes back to the relevant clause at 500 and 82, one sees that it says under D, closure or sealing off of the insured locations, plural, brackets S, plural. So the clause itself is positively assuming that the closure may involve multiple locations. So again, the suggestion of a particular closure of a premises is not one that is either there on the language in the first place, but in fact it's positively consistent with the language used. Looking at the wider clause, and we've already looked at it a bit more, the A to E, one can see that it covers a range of perils. It is, I would accept my learned friend's point, that it's an odd clause because loss of attraction typically or traditionally has a narrower meaning of something which puts you off from going to an area. But this is a clause, and it's not uncommon, where points have been bolted on for whatever reason. It's an expanded version, but it's very clearly an expanded version. And what it deals with is both narrow and broad points. Some points are very narrow, unlawful occupation of premises. Other points, such as extreme of climate, and we say D as well, the closure of rights of way, is much broader. So pausing there, none of the points made in relation to the language are ones that we say are good. But it's not just that my learned friend doesn't get home if it's just the language. It is that we say, when one looks at it, that interpretation which my learned friend is putting forward for the loss of attraction clause is simply not open on the language. For these purposes, it is unambiguous. We can always argue about precise parameters of certain words, but what they do not admit, in my submission, the interpretation which EIC seeks to put on them. And if that's right, if they do not admit that interpretation, it's not a case of rival interpretations that are open on the wording, that, subject to the question of actual conflict, is the end of it. But let me now turn to the overlap with the closure clause. And the focus of the appeal, obviously, is now said to be the profound incoherence and incongruity leading to the redundancy, or the effective redundancy, of the loss of attraction of the closure clause, if you don't read down the scope of the loss of attraction clause so as to be consistent with the cover provided under the closure clause. Now, clearly, if there is a direct conflict or inconsistency, that does need to be resolved. The contract may expressly provide what is to happen in that situation, and we'll all be familiar with contracts which have a hierarchy clause in them to deal with conflicts. It may also be clear from the contract as a whole which provision is to apply. And then, of course, even if that's not available, canons of construction can help. And here, for example, the specific prevails over the general, or written or handwritten terms prevail over printed terms, etc. And so the example, if one has a general provision which says a claim has to be brought within 12 months, and you then have a provision which says any claim has to be, where it relates to breach of one provision, has to be brought within 3 months, there's obviously a clear and direct conflict. They can't both be right. But the obvious answer there, given where there's a direct conflict, is the specific provision in relation to the specific breach of the clause applies over the general. And as I indicated earlier, I do also accept that even if there's no direct inconsistency, but you have ambiguity, then it is open to a court to prefer what it considers the more harmonious or commercial construction. But the warning obviously is what the court can't do is rewrite the contract to be on a more commercial basis, or to seek to find ambiguity in language, which in reality a reasonable person or reasonable policyholder wouldn't find, even if a pedantic line, even if a more pedantic lawyer could find that inconsistency. Now, turning to the closure clause here, I essentially have three main points on the interplay between the loss of attraction clause and the closure clause. First, we say there is in fact no inherent conflict or inconsistency from having cover under more than one clause. That's the point I made earlier, just as there's no particular inconsistency or oddity about a set of circumstances giving rise to multiple breaches under a contract. An overlap does not equal a conflict. Or maybe to be more precise, an overlap without more does not equal a conflict. Now, and in this context, there is nothing unusual about such an overlap, and I'll come back to that. Now, as noted, EIC recognise that there can, on their case, be an overlap between the clauses. Now, as a matter of principle, we'd say, well, that undermines the very basis of the argument that the specific should trump the general. And absent a conflict, because you're accepting that there can be an overlap, there's simply no reason not to apply both clauses by reference to that ordinary and natural meaning. Canons like the specific trumping the general just don't apply if you don't have a direct conflict or inconsistency in the first place.
Well, now, does that follow from, in this case, is this your argument that both clauses are expressed in terms of extension rather than exclusion, albeit one is a limited extension, the other is a wider extension? Now, it may be that the wider extension renders the limited extension odious in certain respects. Do you accept that much?
I would be saying that. I mean, in fact, I'd say it's more nuanced than that in terms of actually how these clauses apply. But yes, as a general principle, that is right. That there is a distinction between saying these clauses cannot fit together. There is an inherent inconsistency. They do not work together. That is a conflict where clearly you need to have some resolution of that question. And if you can't resolve it, as Vogenau says, you end up with a term which is invalid, or indeed potentially with a contract which is invalid. But normally the court will strive to resolve that issue. But if you don't have that conflict, then the starting point, if there is starting point and the end point, if there is no ambiguity, is they both apply. If you have ambiguity and you have a question as to, well, what is the scope of a clause? So, for example, in Marrickville, the issue was, one of the questions was, what should an extended meaning be given to the word damage so there's an overlap? Well, there you clearly have, what the court found, an ambiguity. And then you can have different principles in play, because then you're entitled, as at the court, say, well, actually, I'm not going to prefer a construction which I think is less coherent or less commercial. But that arises only when you get to have an ambiguity. Now, your Honour's already heard my summary at the beginning, because you know where I'm going, which is to say, first, there is no conflict. Secondly, there is no, in fact, oddity or incoherence or uncommerciality. And then the subsequent arguments in terms of, well, even if there were a conflict, is one more special than the other? But at this stage, my point is a simpler one. There is, in fact, no conflict, because both of these clauses can apply, as the judge found. And my learned friend's not saying, well, that makes a nonsense. They cannot both apply. What really my learned friend expanded, and I think he said it on a number of occasions, is, well, that's a more commercial construction. Well, as I said, that does not arise, the commercial construction point, unless and until there is ambiguous language that can be found. If otherwise, you simply apply the language.
Can I just understand that? You would say, if one were to characterize, maybe mischaracterizing your argument, that if one says, all right, one clause says you are covered for X, the other clause says you are covered for X plus Y. So Mr. Walsh's, I think Mr. Walsh's first Venn diagram applies. You say there's no conflict there because they're not inconsistent. It's just one's bigger than the other.
Yes, my only the nuance to be that it depends on obviously what one is saying. So, for example, there is a point of construction, because if one says, well, actually the exclusion, there is in fact an exclusion in one, and that exclusion on its face would appear to be more general. So it's not just saying no exclusion in this clause, but actually the proper construction is it's saying, actually the intention of this exclusion is there should be no cover for disease other than as provided by this clause, for example. Then that would be a straight conflict, and then you would have the special trumping the general. But simply having clauses side by side, which may give overlapping cover, does not amount to something, to an inconsistency which cannot be worked out. But because my essential submission is that the resort to the general, the specific over the general, is an exceptional thing to be resorted to when you simply can't apply them. Otherwise, you apply the natural language in the context. Language is often ambiguous, and if the language is ambiguous, you can interpret it in a certain way. So if my learned friend is right and said, well, actually, the loss of attraction clause is very ambiguous, then I agree, one gets to the next stage of saying, well, how would they fit together? And we'd say, well, there's nothing uncommercial about it. But we say we don't get to that, because the exercise that the judge did in going through language, and which I've taken your honours through, we say doesn't just lead to the point that the EIC don't get home just on the language of the loss of attraction clause, but actually goes further and says, actually, realistically, the arguments that EIC seek to make, what they seek to write in, is not open to them on the language. So it goes further. Because essentially not doing that conflicts with another principle, which is the attempt to give all terms their effect as far as possible. Indeed, that is it. Section 53 of the DIFC rules, or whatever, of the contract law. There are obviously multiple principles at play here. The overall one standing back is always what objectively would the reasonable reader stroke policyholder understand is going on here. So that's the first point. No inherent conflict or inconsistency from having more than one clause. And we say that's essentially recognised by my learned friend accepting that there is in fact an overlap. I mean, he says very narrow an overlap. We'll come to that in a minute. The second point we say it is dealing with this point that there is something uncommercial. Now, we say there isn't anything uncommercial here or anything incoherent. You obviously have my submissions about why the language is clear and there's no scope for reading down. But even if there were ambiguity here, which would allow the court to permit what it considered the more commercial or harmonious reading, that wouldn't help EIC, because having overlapping cover is entirely normal and consistent with the purpose of cover. All the more so where each of the extension clauses here carries its own limit of indemnity. There is simply no redundancy or incoherence in having cover under multiple clauses where the loss claim may, as here, exceed the value of any of one of the limits of indemnity. So Lals's claim is for over 70 million. One of the individual limits of indemnity for loss of the closure clause is 25 million. There is nothing unsurprising about wanting to use up the various limits of indemnity, which, as we say, apply separately and independently. Simply getting the benefit of the extension sport. I mean, that's the other way of looking at it. I mean, if you'd had two policies here, if there'd been double insurance, you'd be entitled to recover both policies, subject to any clauses in the policy which say how you're meant to deal with the recoveries from the other policy. You're in principle, subject not to never making double recovery, you're entitled to both the benefits of both policies. And here, that's essentially what the extensions are. The extensions are separate insuring clauses, and you're entitled to each of the insuring clauses, which each have their own limit of indemnity. Now, it's important to remember that having cover under multiple clauses doesn't result you in actually getting more than your loss or your indemnity. It simply increases the chance, through having the benefit of further indemnities, that you'll make a full recovery. So the fundamental premise that actually this is unnecessary or redundant, and in a way the Venn diagram misses the point that actually what's happening here is there are different layers of cover. If you manage to get the benefit of one clause and you've used it up, if you can use another one up, slightly different terms, you may be able to recover more of your overall loss. You never get it more than your total loss.
So long as the sum total did not exceed your sum total claimed did not exceed loss due to closure and loss due to loss of attraction, you could claim within the limits of each of those provisions. That's saying for the same event, basically.
Yes. Because essentially you've got, and just like it was a breach of contract and it causes two breaches, you have two breaches. I mean, as your Honour will know, insurance policies are in fact analysed by reference to being breaches of contract. Each of them are independent promises. They are the promise to hold someone harmless against the relevant breach. And so essentially the loss of attraction promise is a promise to hold harmless against the loss of attraction elements. And the closure one is for the closure parameters. They're separate breaches. You can't get more than your overall loss, but you can take the benefit of both. And as I said, in a way, the analysis is just as if there were two different policies. Now, of course, often in a policy, there will be some form of aggregate, which is relevant, aggregating things together, or there will be or it'll be clear that both breaches or both indemnities are subject to a single limit. But I've taken you to the point that each of these have individual limits, and indeed they are referred to as applying separately. And it's why we're here. It's why otherwise we wouldn't be having this dispute. We'd be, we're happy that we'll be able to establish cases of COVID within 1 kilometre of these premises. That's not going to be the difficulty. The issue is that's not going to help us with our full recovery. That's why this matters to Lals. And the relevance of referring to cases such as Stonegate or China Taiping isn't really by specific analogy to the facts, because I think my learned friend accepts that they are overlaps, but then says there are specific points on their case. I entirely accept that, but what they illustrate is perhaps it goes against the underlying assumption that somehow something odd about having cover under multiple clauses. There isn't. That's the essential error here, is that somehow it's thought that there is something odd. I mean, I certainly agree this could be a more neatly drafted policy. There's no doubt about that. And so there won't be any quarrel from me on that. But the notion that you recover under each accordance with its terms, that's conventional. This is not unconventional. And that's why what Lord Mance says is so invaluable, because he does the analysis of, is there a conflict, is special, general? But the overall point is that there is nothing inconsistent, i.e. unworkable, about allowing clauses just to operate as they do. Now, I come back to this point of my learned friend's acceptance that there is, in fact, overlap, albeit the characterization of this overlap as being very narrow. Now, the first point to make is a technical one, but it's essentially to say that even a narrow overlap undermines the logical basis of the distinction which is being drawn. Because what is being done in cases like Marrickville is that the underlying logic is that there is a binary allocation to one clause or another by reference to the subject matter of the clause. That's what's underlying it. As soon as you say, well, actually, there are going to be some cases where you might get cover under both, you've undermined that principled distinction, and you're no longer really applying the Marrickville principles. You might be applying the common sense, if this is ambiguous, this is what it should mean point, but you're not applying conflict. Marrickville was a case where the submission was it was inconsistent. Now, whether that was right or wrong, as a matter of fact, I don't need to go into. That was the conclusion of the court. And that's what it was working on, inconsistency. That's not the position here. But so that's the overall point. But actually just checking the point of saying, well, that's being overly technical, because the reality is the overlap is very narrow. Look at my Venn diagram. But well, we say that clearly isn't so. On EIC's interpretation of what is meant by the loss of attraction clause, i.e. something local where a police or someone equivalent turns up to the premises, that's going to cover pretty much every murder, manslaughter and suicide case. So if we go back to page 580, which sets out the closure clause, we have the various underlying perils are manslaughter, murder and suicide. Well, if someone dies through any of those three, it's overwhelmingly likely that the police are going to turn up and order the police. So it's going to be covered under the loss of attraction approach. The next one is vermin or other pests. Well, leave aside for the moment the situation of a locust plague over an entire city, which I think some Indian cities recently suffered from. Leave aside that. Take the classic example of rats or cockroaches in the premises. Well, actually, typically you'd be expecting there's going to be some sort of person turning up and closing you. That's how they're going to know. There's going to be some health inspector turning up and saying, you've got cockroaches or rats, you close. Again, so the typical situation where the closure clause would apply, it would also apply on the loss of attraction clause on my learned friend's analysis. It's something local, it's an enforcement official who's able to close it. On any view, be some sort of law enforcement for the purpose of closure, one would have thought, and amount to closure. And indeed, even on disease, so for example, I don't know, a case of Ebola at the premises, something dramatic. Again, that's going to involve some health inspector turning up and closing the premises, or someone getting food poisoning. When's that going to lead to closure? Well, when someone's inspected it and said, your place isn't healthy, close down. All of these, actually, the paradigm examples of the closure clause are cases where someone's going to turn up and close you. The only things that are actually excluded on my learned friend's construction, in reality, is likely to be some form of widespread disease where the order is general. Where the police or the health inspector isn't going around each premises, but actually just saying, everyone close, we need to close. And as I said, that might cover the plague of locusts as well. If you know you have a plague of locusts coming over your city, the city might say everyone needs to be closed for the next 48 hours. To keep everyone safe. Again, that won't be a closure, but the classic examples of each of them will involve closure. So far from my learned friend's Venn diagram of there simply being a little bit of overlap, it would be almost complete overlap. Now, if I were being cynical, one would suggest that my learned friend's construction is really an ingenious one, engineered to exclude the COVID-19 pandemic, because that's really what it's referring to. Pretty much all the other perils, the classic examples, would be covered. But because of the generality of it, because it's being done at a regional or national level, it's somehow excluded. And we say that that sort of construction is in fact much more artificial, incongruous, incoherent than the one of simply letting both clauses apply on their standard terms. Now, the third point is, even if my learned friend can get over the lack of conflict, the lack of what we say is any ambiguity in the wording, relevant ambiguity in the wording, and the fact that it is perfectly reasonable and normal to have overlapping cover, he would still falter at being able to say one clause is overall more specific or calibrated than the other, or putting it perhaps more generally, that one clause should, on a true construction of the policy, trump the other. Because what we say the right answer is that each clause has bits that are wider and bits that are narrower. So if we start with the loss of attraction clause, 582, it's worth making a number of observations. First, this is in fact a much longer clause, more than twice as long, as the closure clause. Not a promising start to say one's more specific than the other, but there we are. That's the first point. It's also wrong to say that the clause as a whole is general. Clearly, some of the perils are very specific, harmful devices, unlawful occupation, etc. It also has, when one looks under the final two paragraphs, more detailed provisions as to what is meant by prevention of access in circumstances where, in fact, as in this case of them, you have shopping centres or complexes and how that's to be treated. It also has an aggregate limit. My learned friend took you to this, but perhaps we should just go back to it. Page 546. Loss of attraction, limit 25 million, any one occurrence, and in the aggregate, 48-hour excess. So this policy will only cover you up to 25 million in total in the aggregate. By contrast, we'll see this in the closure clause, there is no aggregate provision for the closure clause. So if you have different occurrences, you'll have different limits of cover, subject to the overall limit of the insurance policy. It also has, if we look at page 546, what is a 48-hour excess. Now, a 48-hour excess may sound like an odd concept, but in the context of business interruption insurance, it's not unusual to say, well, actually, for the first 24 hours, 48 hours, etc., of interference, you don't get any cover. So it's not a financial limit. It's just saying if you've just had something interfered with for a day or two, this policy is not responding. It's obviously controlling the level of risk. So it's basically taking out of account the first 48 hours of the policy. So, and if one stands back on the closure clause, that is going to cover the overwhelming majority of closures. So the fact that a road's closed for an hour or two, well, you're just never going to get cover on this policy. It's just not going to lead to anything because it only kicks in after there's been a 48-hour. I mean, sometimes described as a 48-hour waiting period. It can be described as different ways in different policies. But here we've got a 48-hour minimum period before anything kicks in. So this is a policy which is more limited in application than the closure policy we'll look at because it has an aggregate, which the closure policy doesn't have, and it only applies after 48 hours. Now, if we turn to the closure clause, I certainly accept some bits are narrower. For example, the reference to specific perils to murder, suicide, disease, but it responds immediately. On its face, the language is different. So it, for example, refers to evacuation of all or part of the premises, which the closure clause doesn't. Now, I can obviously have arguments as to how the closure clause should be interpreted, but the language is clearly on its view different. And significantly here, just for when we come to Marrickville, etc., there's no exclusion of any class of disease. Because you may recall in Marrickville, one of the points that the court considered important was the point that there were exclusions and which would be bypassed if you had cover under another clause. Here there's no exclusion. It's simply saying that there is cover for this, but it's not trying to say, but there isn't cover for other things. It's simply providing cover generally for contagious diseases and murder, etc. Structure-wise, and I think it's a point Your Honour Justice French made earlier, these are both extensions. This is not a case where there is a general insuring clause where the analysis is it's then qualified. These are separate extensions which are set out, but I think if one looks at the list broadly alphabetically, they seem to lose alphabetical order at the end. Again, another point of inconsistency, but they start off alphabetical, the various provisions set out in the thing, and then they end up not alphabetical, but not with any form of priority. So you can't find, we say, any form of express or implicit priority of the clauses. They're not next to each other. It's not like Marrickville where one came immediately after the other. They use different types of language. We've seen different language of insured location, insured business premises, etc. And each has its limit of indemnity, which apply in addition. So this is not a case where one says one is more specific than the other. You then add on to all that the point that I made at the outset, and which I think my learned friend doesn't disagree with as a principle. These are pick and mix mixture of clauses. And we say that that again goes against any objective intended priority as between these extensions, or that there's an assumption that there should be a precise delineation of cover between the policy. You can do that. It might be an easier thing to assume where you have a standard form contract drafted in a unitary way, because that wider structure, that unitary construction may be easier to say it's been allocated one way or another. I mean, even then, I mean, China Taiping was in fact a standard form contract, but it didn't apply then. But you can see that it gets you closer to saying how it should be allocated, but that just doesn't apply. So putting it all together, we underline, it's a case where each of the extensions carries a separate and additional limit of indemnity, and that works against the idea that any of these extensions should or should be assumed to trump the other. Why should what the reasonable reader would be reading through when reading what cover they have under the schedules, and indeed under the clauses, be thinking, well, I've got this 25 million for this, I've got 10 million for customer extension, I've got 25 million for this. Thinking, well, actually, no, you don't have it. Because although it says for each extension, because of clever, loyally reading, we should somehow read down for certain purposes, but not for all purposes, the scope of the loss of attraction clause. We say that that is both incoherent and artificial, and certainly not how a reasonable reader would understand this. Can I just then turn to Marrickville, given that it's the perhaps the key case that my learned friend relies on for his proposition. And I make a point that I made earlier, which is that the case that EIC is running is different from Marrickville. EIC is not saying that all disease and murder is implicitly excluded from the scope of the loss of attraction clause because of the closure clause. There's not that binary allocation that there was in Marrickville. It's accepted that there is an overlap. And as I said, that the principle is not disputed. So this is not a case where I need to say Marrickville was wrong as a matter of principle. I accept that interpretation may well lead in certain cases, certainly where you have standard form contracts, that one coverage clause should be read subject to another, and on questions of construction, the questions of construction that the court raised were, are or ought to be uncontroversial. There is perhaps, and I think this is a point that the judge below may have alluded to, there is perhaps a slight difference in approach between Marrickville and the English approach. And in a way, it's not a point of principle of construction, but it's perhaps an unstated assumption. And the unstated assumption, perhaps, and I don't put it any higher than this, is that Marrickville perhaps can be read as assuming that there is something odd and incoherent about there being cover under multiple clauses. Whereas we would suggest that the correct approach adopted by Lord Mance, and indeed in the other cases related to the overlap, is there is nothing inherently odd without more. There may be wording in a policy which makes clear that it's not intended, and there shouldn't be an overlap, that there's only a single limit. But those are different cases. But as I said, that may be a difference of emphasis, and it's probably what the judge meant when he said he preferred the approach of Lord Mance. It's not that the principles being applied are differently, it's perhaps that the underlying assumption is different. But Your Honour, I mean, turning to the specifics of Marrickville, it was a different type of case. It appears to have been, as we say in our skeleton, a standard form off-the-shelf policy for small businesses. This was a restaurant and bar. What you had, and perhaps if we just look at the clause, page 517. Sorry, that's an incorrect reference. Page 2108. And what we can see if we turn the page to 2109, where the cover is set out, it starts at 2109. The relevant provisions are 2110. And at paragraph 501, it refers to this policy being typical of an industrial special risk policy. Then refers to the extensions. And then we see paragraph 7, the prevention of access clause there by a public authority. And we see there we will pay for loss that results from an interruption of your business that is caused by any legal authority preventing or restricting access to your premises or ordering the evacuation of the public as a result of damage or threat of damage to property or persons within a 50-kilometre radius of your premises. And we can see that's a fairly short provision, what the court described as general, four lines or so. We then get to the murder, suicide and infectious disease provision immediately afterwards in clause 8, where we see there's obviously a much more detailed analysis, I think it's 4 times longer, of where murder disease is covered. And one can see there's a specific exclusion there for highly pathogenic avian influenza under the policy as well. So it's both set out in scope and so the scope of there's a closed list and there's an exclusion. In contrast the position here where we say that there is no such exclusion, and obviously the alleged special clause and the alleged general clause are not next to each other as they are here. The key question in Marrickville, for the present purpose of reading together, was whether the damage in the denial of access clause should be given what the court was considered an extended meaning. So if we turn back to 2110 at the bottom, the question was whether ordering the evacuation of the public as a result of damage to or threat of damage to property or persons within 50 kilometres of your premises encompass disease. And the judge below had started off by concluding that actually physical damage to persons didn't sound like it included disease. And we see this picked up if we turn to paragraph 520, as to what the relevant question is. 520, middle of, it would be illogical to suggest that clause 8 is irrelevant when an insured makes a claim consequent upon the outbreak of an infectious disease, merely because the claim may be covered by clause 7 if the word damage was given an extended meaning. So the context is whether to give something an extended meaning. That is, and then it goes on to underline actually the key point of distinction. As Insurance Australia submitted, it would offend the principle that specific provisions prevail over inconsistent general provisions concerning the same subject matter. So again, the court here is considering the submission that they are inconsistent. And you have my submissions, there is no inconsistency, but that's the context of this dispute. So the relevance of this is this is not a case of removing cover that was prima facie there on the language, as we say is the position here, because we say the loss of attraction clause prima facie covers this. Marrickville was a case of saying, well, actually, damage wouldn't cover this unless it's given an extended meaning, and we shouldn't give it an extended meaning because of clause 8, which deals specifically with the question of disease. We say that there is a distinction between removing the cover that was prima facie there, which is our position, and not extending cover so as to create an incongruity, which is really the position of Marrickville. Finally, and I put this softly because we don't have the benefit of the whole policy in the Marrickville case, but it seems likely that this was a case where there was a single limit which applied across the business interruption clauses. I say that because that must be the premise of saying that having cover under both would be redundant. Otherwise, it wouldn't necessarily be redundant if you could have two limits applied. There would be a benefit in it. So I'm assuming that the reason that point was not made by anyone was because there was only one single limit applying. I also note that when there is a reference, and this is all a negative point, to how the policy worked, for example, in the context of how the adjustment works, it's paragraph 609 to 613, there's no distinction, there's no reference to two separate limits applying. Now, as I said, I raise it because if that's right, it obviously also provides another understandable explanation as to why it might be said that the clause would make the more specific calibrated disease clause redundant, as there would never be any purpose of seeking to satisfy that clause. And it would also mean that the exclusion would have no effect. And you could say, well, what's the point then of having the exclusion of the disease clause if in relation to the same limit of indemnity, if you could simply bypass it? And even if that's not strictly an inconsistency, it would certainly be an oddity. But as I said, here, there is, as I've said before, simply nothing inconsistent, as I've identified, in having cover under multiple insurance clauses, which have different requirements. So it's not just the different limits. The loss of attraction clause will be used up much earlier because it's an aggregate limit, it's 25 million. Once that's used up over the year, over all the territories, it can't be used up again. The closure clause continues to respond, subject only to the limit of insurance. Similarly, a lot of the cases would end up not being covered in the case of, a lot of the what might say classic cases under the loss of attraction clause would in fact not lead to cover because of the requirement of a minimum of 48 hours. That reminds me of one point that perhaps I should just clarify on the business interruption, on the excess point, just so our position is clear on it. If one goes back to the policy, and in particular to page 548, You'll see there, that's the slip. You'll see there that the reference in the middle to deductibles. Under property damage, there's a reference to 50,000 each and every loss, and then a specific one for portable equipment. And under business interruption, it says 5 days. Now, if we go back to the extensions, we can see where the business interruption excess applies. So if we go to page 545, customer extension, it says BI excess to apply. See that under supplier extension on page 546 as well, BI excess to apply. In relation to loss of attraction, there is a reference to BI excess, but of course the specific figure, and here to get specific in general, is the 48 hours that's supplied. If one looks at the closure clause, closure due to vermin, there is no reference to business interruption excess to apply. So there is no business interruption excess. Now, one might say, oh, if my learned friend were to say, I don't know if he will say, but if he were to say, oh no, well, the business interruption must implicitly be applying to each of the covers under the business interruption specific clauses, we can show that that's not right, because if we look at the beginning of section 2 business interruption clauses, page 579, we can just take an example. Accounts receivable, which is the first limit, which is referred to, and doesn't say business interruption loss. So on this assumption, it would be, well, although it doesn't say business interruption loss, it might still apply. And the answer is, well, no, it clearly can't apply, because accounts receivable is cover for the loss of records or accounts kept on the premises which are lost, which essentially mean you can't get the money back because you've lost your accounts. That obviously has nothing to do with saying you don't get the first day or the first 2 days or first 3 days or first 4 days. It's not something that logically makes any sense. So unlike the position with the property damage deductibles, which expressly say we'll call each and every loss, and so apply to everything, the business interruption deductibles only apply where stated, because the schedule doesn't say they apply everywhere, and they apply where stated, and they are stated in specific ones. They're not stated in all of them, and I would say that's the end of it. But if it were to be said, well, even though it doesn't say each and every loss or in the schedule, that must be effectively what should be read in, one will say, well, that cannot be right, because if you just take the first example, and I've just taken the first example for others, that business interruption cover under section 2 doesn't make any sense with a 5-day excess. What it probably is that customer and supplier cover is actually quite a broad form of cover, because you're insuring someone for the consequences of other people's consequences. So it may be the logic, and I'm simply speculating here, was that there was particular concern about cover for those. By contrast, something like closure, which is much more narrowly focused on what precisely will trigger, that concern may not be there. Whereas by contrast, for loss of attraction, obviously that because it's results based, is potentially much broader, but that breadth is in fact very significantly cut down by the fact that it doesn't apply for the first bit, because you need to get over the excess period. And even when you do get cover, it's a more limited form of cover, because it's an aggregate cover, as opposed to a cover which would otherwise be each and every occurrence up to, subject to the full some insurer. So that was a bypass, which was just on the deductible point. The final case, just to say something about, and again, I don't think I need to say much about it because the judge has dealt with it. It's the China Taiping case. I accept my learned friend's point that that he made on a number of occasions, that one has to be cautious about all these cases and trying to apply by analogy, etc. Albeit we all fall into the trap then of trying to do precisely that when it suits us. But in a way, the point that we rely on for China Taiping isn't so much the specific wording, and I'll make a few points as to relative comparison, which may or may not be of assistance. But it is for the key point that there isn't anything unworkable, or indeed, as the judge thought, that Lord Mance, extremely expensive insurance, didn't suggest there was anything inherently odd or uncommercial about this, in simply allowing the terms to apply as drafted. That's perhaps the most important point of just, and in a way, if there's one criticism of Marrickville, it is that when it considers the Lord Mance's analysis, in a way, it doesn't deal with that point. It starts from the assumption that there's something odd, as albeit then goes on to perhaps more standard points of principle about specific over general. In terms of the short points that I can make on it, subject to the point about danger of analogy, this again was a standard form policy. That's clear from paragraph 1 of the award. And it was a case where, in a way, stronger than this case, because the clauses were numbered and are next to each other, i.e. more structured. It's easier to say that one's intended to qualify than the other. And indeed, there was an exclusion in this clause, in the one before Lord Mance, which again might be said to be a point in favour of exclusive interpretation as opposed to overlapping interpretation. As you've seen, Lord Mance concluded that there wasn't anything more specific about one clause or the other. I don't go back on that. That is what he concluded. But he did go a bit further than that. And if I can just take Your Honour to Your Honours to the relevant passage, it's page 1. Sorry, Your Honours. Page 1287. It's paragraph 24. And the starting point there is the reference to the two very specifically worded extensions. But he goes on to make another point, which we say is relevant here. And it's a point I alluded to at the very beginning. The policyholders also point out that insurer's case accepts necessarily that there's no express exclusion of any notifiable disease from the scope of perils embraced by extension 1. And it assumes, read by itself, the wording of extension 1 would be engaged, at least to some extent, by the circumstance of the policyholder's claims arising from the COVID-19 pandemic. There are examples in the Divisional Court's judgment, that's in the FCA case, showing how easy it would have been to fashion an express exclusion, whether by reference to infectious disease more generally or specified diseases. There's no certainty which approach might have been adopted. A clause of the former nature could have assisted the insurer. A clause of the latter nature would almost certainly not have done so, since COVID-19, being largely unforeseen as such, would in practice not have been specified. The policyholder's case is that the insurer is in substance seeking to introduce a clause of the former nature without express or implied wording to justify this. And if we then turn to paragraph 26, the judge then notes, Lord Mance then notes the potential for duplication of the two and says that it's considerable. But then over the page, he goes on, page 1288, 3 lines down, whatever insurer's case on that, the position is that the policy could have made clear the interrelationship between extensions 1 and 2 by excluding from extension 1 all or any aspect of the perils to which extension 2 refers, but it does not do so. And then it refers to 1b does in fact do so. And then move down, the absence of any exclusion by reference to a notifiable disease or to all or any perils or elements in extension 2 is in this light notable. Now, again, these are all clause-specific arguments, but it is a point, especially when one's looking at this from the view of a reader, that when something could easily have been done, and it's not been done, you can draw a point from it, only so much. But there was an obvious point to make this clear. It was not the point adopted, and the effect of what's being suggested is in reality to remove cover that I think my learned friend almost accepted, that, you know, without the closure clause, there would be cover on the loss of attraction clause. I really didn't quite go there, but certainly a much more difficult case, perhaps even he would accept if you didn't have it. All of those points could be avoided by simple language. And the point that is made in paragraph 24 is instructive, because it's not just that you could have said something, but in a way it illustrates the point that it could have been done in different ways. Because this is my point about incoherence and incongruity. My learned friend has gone down a route of saying, well, actually, let's read it together in a way that I'm going to say that the loss of attraction clause requires someone specifically to turn up locally to come and close it down as a result of a specific incident. But you could also have read it as an exclusion, effectively saying where the loss of attraction, where the closure clause applies, there's no cover on the loss of attraction clause. And it's the point about saying, well, you get the uncertainty. And as soon as you start saying, well, actually, you could do this in different ways, it's a strong pointer to say you shouldn't be doing anything at all. You should simply be applying the clause as written, where it's not ambiguous, we say. Even if it's ambiguous, is there anything odd about them both applying? No, there isn't, because there is a commercial reason for it. There's a commercial benefit in having cover under multiple covers. Of course, my known friend doesn't accept that we have our losses yet. I mean, hopefully he will do at some stage, but you know, it may be that we only have losses which come up to the first limit and it becomes academic. But the case that we're putting is that the losses that we have significantly exceed those that would be recoverable under the closure clause. And so there's every commercial reason, objectively, to want to get the benefit of each. There's nothing uncommercial about having covers for slightly different risks. And as I said, they don't overlap. The loss of attraction clause, sorry, they do overlap, but they have different specifics. And so we do say that when one stands back here, when one looks how a reasonable reader would look at this policy, they wouldn't see any inherent conflict, because there isn't any, and they wouldn't expect what on their face they are given by the loss of attraction clause, including specific position in terms of the limit of indemnity and the aggregate, etc., to be taken away without clear wording, none of which is here. Your Honours, unless there's anything further I can assist on, those are my submissions.
Thank you very much. So your case, very simple again. The clause here, interpretation is clause specific, and there is no inherent conflict between two clauses, and both can run together. Basically, yes. That's what you're saying.
And there's a commercial justification for it.
Yeah, no commercial justification. Okay. Can we take a 5 minutes break? Can we take a 10 minutes break? You know, I need to go to the. So I'll just close here for 5 minutes. I come back.
20
Yeah,
past,
just
or 20 past?
What's the time now?
It's 10 past now.
Well, 20 past, 10 minutes. Make it 10 minutes break. 10 minutes break. So I'll turn off the video. Yes, Mr. Walsh, you ready?
Thank you, Your Honour.
Thank you.
I will be as brief as I possibly can, and I will touch on a number of points that my learned friend has just raised. The first is this. My learned friend said that if there were two equally available constructions on the language, the judge could not be said to be wrong.
Yes.
Now, we agree that the litmus test on the appeal, the relevant question is, was the judge wrong? We agree with that. But we don't quite agree with the way that he put the point, or at least our understanding of the way the point was being put. If there were two available constructions on the language and the judge should have preferred one because it was more commercial and failed to do so, he was wrong. And we see that for lots of cases. Rainy Sky would be an example. It's a well-known case, don't need to turn to it, but there you had the commercial court saying one construction was uncommercial, and the Court of Appeal disagreeing by a majority overturning that, and then the Supreme Court overturning the Court of Appeal. The Court of Appeal didn't say, well, the judge's conclusion was that the construction was arguable, so our hands are tied. So that we say the way that it was put, it puts the point just a bit too high. The second point that I wanted to address, my learned friend said that the fact that the limits stack answers the redundancy argument that we make, and we say he's wrong about that. The argument that we are making is that you shouldn't get cover for a closure unless the detailed requirements of the closure clause are met. You shouldn't be able to say, well, the closure wasn't due to a murder or an infectious disease or anything else in that closed list in the closure clause, but not to worry, I've got 25 million dirham of cover anyway under the loss of attraction clause for closures for any reason whatsoever. That's our argument. And the fact that you can, in certain limited, we say, circumstances, potentially trigger both clauses and get two limits doesn't answer that argument at all. The third point.
Can you explain that again, the last part? You said no claim under closure clause. Where was that again? Can you repeat what you just said on the closure?
Yeah, so my learned friend said in his submissions, he said, well, look, the limits stack, they're one on top of the other.
Yes.
So in other words, if you can burn through your 25 million on loss of attraction, and if your losses are in excess of that, you can then pick up the losses on the closure clause.
Yes, that's right.
And he said that answers the redundancy argument because it shows that there's a point to both provisions. Well, we agree that there is a point to both the provisions, but it doesn't answer the redundancy argument that we're making. The redundancy argument that we're making is that you carefully prescribe the circumstances in which you get cover for closures under the closure clause. And then it makes no sense to then say, well, on its proper construction, you don't need to satisfy any of those requirements under the loss of attraction clause, and you just claim for a closure under the loss of attraction clause, and you get 25 million worth of cover under that clause. That's the argument we're making. And saying that the limits stack on top of each other, if both are engaged, doesn't address that point. We're dealing with a case where the limits, the scenario we're considering is one where the requirements of the closure clause are not met. Then we're saying, well, hang on a sec, it can't be right that you can just say, well, we went to the trouble of identifying all these reasons why you could get cover for a closure, and then we can just ignore them and just get cover under up to 25 million under the LOA clause instead. The third point, my learned friend said a number of times about how inelegantly the policy was drafted, and we can agree on that. But the point doesn't really go anywhere in the sense that you only get into debates about conflicts between clauses, about overlapping cover, about cover being subsumed, where that's the sort of policy that's in front of you. If it was seamlessly drafted, there would never be an issue. And so all the cases where these sorts of points arise are cases where there is perhaps inelegant drafting. Fourthly, my learned friend said, well, if there's doubt about construction, you should construe it in a way that doesn't construe the policy in a way that doesn't deprive business interruption cover. And that is not a principle of or rule of DIFC law. And it's not that perhaps this is the problem, is viewing, if you view things through the eye of a reasonable policyholder, you think that every tiebreaker should be resolved in favour of the policyholder, but that's not a principle of law. You don't just say, well, it's uncertain, therefore I err on the side of giving cover to the policyholder. That's just not a principle of law that's recognised in the IFC law, or so far as I'm aware in any common law jurisdiction either. Fifthly, this is the point that my learned friend made about inconsistency. He said, well, inconsistency is where you have one clause in a policy that says go left and another clause in a policy that says go right.
Mm.
And of course, clearly, go left in one clause and go right in another are the stark examples that one can give of an inconsistency. It's telling you to do completely inconsistent things.
Mm.
But it is also inconsistent to say, on the one hand, the cover is only extended for closures in these particular circumstances, and on the other hand, to say, well, no, you get it cover extended for closures for any reason whatsoever, and that's just as much an inconsistency as saying go left and go right in different places. And that the court will recall the passage that I took you to from Lewison, where it quoted the Irish case, and where it was saying about the specific and the general. And the way it was described there was, if a particular situation is dealt with in special terms, and later in the same document you find general words which could be said to encompass and deal differently with that particular situation. And that is what we say one is looking at for an inconsistency. And if that's the test, it's certainly met on the two clauses that are before your honours. Sixthly, in terms of language, you don't need to use the word local for that to be the implication of the words used in the clause, and that's our case really. Of course, you don't have to actually say in black and white, by the way, this is local. What you're doing is reading the words and ascertaining what the parties meant by it. The radius is obviously a key figure or key factor in the local element of the cover. My learned friend said, well, that wouldn't apply to things like extremes of climate. Why not? Why not? It's not about locating the center of a storm. What it's saying is you get cover for extremes of climate if the extremes of climate are within the radius of the insured location. That's what it's about. So the idea that you can, I know it's a pick and mix policy in some ways, but you can't pick and mix which bits the radius applies to and which bits it doesn't. And that does strongly point to a narrow localized form of cover. On the meaning of other statutory authority, I think my learned friend is tilting at an argument we're not making. We say that the reference to the radius and sealing off and things like that points to this being a local form of cover, something happening locally at the premises or within the radius. But our point on statutory authority appearing after the reference to the police is that it's referring to something like law enforcement. It's not saying that is, oh, well, that shows that it's a local cover because the police have local constabularies or anything like that. That was the argument that was being addressed in the likes of Corbyn and King and Gatwick. I'm not rerunning those points, and the point I'm making is a rather different one. My learned friend said that sealing off is not necessarily local, and he gave the example of the gas board, saying that you need to leave, and that would be a sealing off. We do say that is a somewhat unrealistic use of the expression. It wouldn't be a natural use of language to say the premises has been sealed off because the gas board phoned you and said there's a gas leak. So we say that the way that we read his written argument, which was effectively accepting that sealing off is a local connotation, is the right way of viewing those words. My learned friend also said that the clause as a matter of language is unambiguous. And we say that is a very ambitious submission, where my learned friend laboured the point at the beginning of his submissions about how the clauses weren't models of precision. And even the judge at first instance accepted that the word sealing off of the insured location and the radius had a local connotation. So we don't say that the wording, it can't possibly be right that the wording is unambiguous and unambiguous in Lals's favour. When it comes to conflict and ambiguity, I've already touched on this briefly. We agree that overlap does not mean conflict. So that was the second Venn diagram at the end of our submissions. There was overlap. And a point that was made by my learned friend multiple times is that EIC proceed on the basis there's something odd or incoherent about there being cover under multiple clauses. It's a criticism he also made of the courts in Marrickville. But we don't say it's odd or incoherent to have cover under multiple clauses. As we said, our complaint is that the closure clause is totally subsumed on Lals' construction within Lim D of the LOA clause. It's the first Venn diagram at the end of our submissions. That's the complaint. Justice French asked about the fact that there are two extensions in this case rather than an exclusion and an extension. And that is right. We're dealing with two extensions to the cover, two extensions to the standard BI offering under the contract of insurance. But we say that one shouldn't read too much into the fact that one's an extension, or sorry, that we're dealing with two extensions rather than one extension and one exclusion. Marrickville was also dealing with two extensions to the cover. And it would have been equally an answer in Marrickville to say, well, clauses 7 and 8 were both extensions. And that wasn't an answer in Marrickville. It's not an answer in this case. As I say, the complaint is not that you may be able to get cover under two clauses. The complaint is that the carefully constructed limits of the closure clause are totally subsumed within the cover offered by, on its face, offered by Lim D and on my learned friend's construction. And we also say that the modern approach to construing contracts of insurance is not to get overly concerned with the fact that a clause is an exclusion. Certainly that's the approach in England. You look at the exclusions and the cover as a whole to work out holistically what the ambit of the cover that's being offered. And we say that's what the court should do in this case. But as I say, the fact that they're both extensions can't be an answer to the point. It wasn't an answer in Marrickville. My learned friend said on our case, the overlap is not narrow. The overlap between the clauses on our construction is not narrow. So I think he's quibbling with the amount of overlap in the second Venn diagram at the end of our submissions. Maybe it should be a slightly larger overlap, I think, is the point. But we don't accept that the overlap is in any way substantial. My learned friend said, for example, that rats or Ebola would engage both clauses. But it's most unrealistic to think that would prompt the police or law enforcement body to turn up and physically shut down the premises because there's some rats. I mean, it might engage someone from the environmental health department, but it's not going to get the police or law enforcement coming along. Also, importantly, my learned friend made great play of the fact that this 48-hour waiting period, which we see in the schedule for the LOA clause, and we can have a debate about another day whether it's 48 hours or 5 days plus 48 hours or 7 days. That's for another day. But if, for example, you had let's assume it's 48 hours for the moment. If you had a suicide, fortunately outside the insured location, the chance of it still being physically sealed off 48 hours later or longer, I mean, it's very unlikely. We're not talking here about a scene of crime that might be erected quite quickly and then disposed of. So we do say that the clauses are dealing with different things, and that the overlap between them is indeed narrow. What's critical, though, is that my learned friend doesn't challenge the first Venn diagram in terms of the effect of his construction. He doesn't say, no, it doesn't work. There's no, on my construction, the closure clause still has a life outside of the LOA clause, Lim D. It seems to be common ground that it is subsumed. The only point he says is, well, hang on a sec. If both are triggered, I can get my cover stacked. But as I say, that doesn't answer the key complaint, which is if you don't meet the requirements of the closure clause, why, construing the policy commercially, should you get cover for a closure? And that's our complaint. Now, in terms of the argument about whether, in fact, we have a general and specific clause in this case, we say that trying to say, well, okay, well, the LOA clause actually includes lots of other things that are entirely irrelevant to closures, and therefore that must also be a specific clause. I mean, that cannot be right. What we're dealing with here is we have a clause specifically dealing with closures, fashioned to deal with closures. And the argument is you have another clause somewhere else, which is very general and deals with closures without being concerned about the reason for the closures. Should you read that down? Sorry, Justice French, looked like you were about to interject, and please interrupt me.
No, I was just musing about the dangers of using taxonomy as a prior condition for a construction. It's really a matter of construction. I suspect, you can draw a long spectrum in which things can be specific and slide into the general. And I understand that it's an aid to an approach, but I don't place much store on the labels.
Well, I take your point, Your Honour, in the sense that there may be degrees. There may be degrees, but perhaps what we can agree on is that insofar as it refers to closures, Lim D of the loss of attraction clause is plainly much broader and more general than the closure clause. And that's the relevant issue here, not the fact that it also deals with another limb that deals with extremes of climate. And so, well, okay, well, that's got no relevance at all to what we're talking about.
Well, the real dichotomy is between a narrow extension, a narrow relevant extension, and a broad or broader relevant extension.
Exactly. In other words, you look at the relevant bit of the loss of attraction clause that overlaps with the other cover, and that's what we're inviting the court to do. And so in Marrickville, you didn't look at the more general clause and say, oh, that also, as it does, refers to property damage. So that's also quite specific. I mean, that's just irrelevant. Marrickville, we agreed it's not the same policy wording, and my learned friend drew some distinctions. That's fine. It goes nowhere in terms of the underlying rationale. My learned friend suggested there was some importance in the sequencing of the clauses, that Marrickville, the clauses were adjacent, clauses 7 and 8, whereas in our case, the LOA clause is on the next page or wherever it is from the closure clause. I mean, that can't sensibly be a basis for distinguishing the cases. The issue in that case was whether clause 7 should be construed broadly or narrowly, given the presence of a specific clause dealing with closure. That was the issue. And it's the way that Justice Jago and the full federal court grappled with that particular issue, which we say is instructive, and we invite you to adopt in this case. Lastly, on Marrickville, my learned friend made, and in fairness to him, he said this was an assumption. He speculated about whether there was a single limit in Marrickville. We don't have the whole policy. The bit of the policy we do have, I think, that's quoted from the judgments is just the standard terms. So we have no idea whether there was a single limit in that case or not. China Taiping, my learned friend didn't press the case too hard. He accepted that it was all clause policy specific. We do say, however, that arguments to the effect, oh, well, you could have written the clause differently, are never very powerful, and they're certainly not powerful in this case. My last point, the reasonable reader. This elusive character that was, or policyholder potentially, who was referred to. We've already alluded to the fact that it doesn't mean one takes a one-eyed view in favour of the policyholder. The critical point is that, again, drawn out by that Irish case that's cited in Lewison, which I keep coming back to because I think it is the best common sense explanation of the argument. I quote here, "It is a common sense way of giving effect to the true or primary intention of the draftsman, for the general words will usually have been used in inadvertence of the fact that the particular situation has already been specifically dealt with." And that is common sense. You may even say it's homespun, but it reflects a reality. And that is what we say the court should be alive to in this case, and for those reasons, we invite the appeal. Your Honours to allow the appeal, and unless I can assist you any further, those are my submissions.
Any questions?
Your Honour,
yeah.
Yes. I was just going to try and clarify one point, because I think my learned friend said we were in, there was no dispute about the overlap of the Venn diagram. So just to clarify, we don't accept that there would be overlap or complete overlap for the reasons that I gave. That is to say that in some cases loss of attraction won't apply because of the 48 hours, it'll never trigger. Sometimes it won't apply because all the monies will have been used up because of the aggregate. And indeed, as I pointed out, there is also different language in terms of part of premises evacuation as well. So those are all reasons why we say we don't accept that premise, although we certainly accept that there is overlap. The only other point I would ask is if Your Honours do look at the Lewison passage, perhaps just to read on, because there's a useful passage that continues in that, which makes the whole thing slightly more nuanced than perhaps just the Irish judgment suggests.
Yes, I'm sure we'll go through them again. Don't worry about it. So there's any more question from you, Justice French?
No, that's great. Thank you very much.
Thank you. Thank you very much. Thank you very much for your very useful, very interesting arguments that you have put in. But at the end of the day, I think it's interpretation of the contract as both parties agree. I think how do you interpret it? You know, whether you reduce the attraction clause or you can run together. So those are the things that we have to decide, of course. And I think we will require some time. Come back to you as soon as we are ready with our judgment. And the registrar will keep you informed. But thank you very much again for your kind elucidation of all the points you have raised. Thank you very much. So the court is adjourned. Judges, can we go back to the other link?
Yes.